Jen, evo Ladies and gentlemen, dear colleagues, welcome to the third Internet Dialogue, a cycle of conferences co-organized by the University of Belgrade Faculty of Law and the Serbian National Internet Domain Registry Foundation. This year, the Internet Dialogue is dedicated to online platforms, and the title of this conference is Repositioning Platforms in Digital Market Law. Contrary to some of our previous conferences, this year we are organizing a conference entirely in English, since we have international participants coming from more or less 10 countries. So I will try to enumerate them since I didn't bring my list with me. So it will be Germany, Slovenia, Poland, Italy, the Netherlands, Australia, China, Serbia, and Hungary. Hopefully I have Cyprus. I have now mentioned all of the countries. I would like to thank all of my colleagues for having accepted this invitation, and most of them came to Serbia for the first time. I'm sure that this will not be their last visit to Serbia and the last occasion for us to cooperate. This conference is also a part of a wider project which will finish in 2024 when we will publish an edited collection on the legal framework for online platforms, and the book will be published by Springer. I would like to thank my co-editor, Dr. Rainer Kulms, for his support. This conference would not have been possible without the support from Getzich Law, and I would like to thank the law firm Getzich Law for being our partner this year. You have already noticed that I'm alone here, since both the director of the Serbian National Internet Domain Registry Foundation and the dean of the Faculty of Law are presently not in Serbia and not in Belgrade. We will listen to their video recorded messages, welcome addresses, and I would first give the floor to Professor Zoran Mirković, Dean of the Faculty of Law, University of Belgrade.
Ladies and gentlemen, dear colleagues, welcome to the conference Internet Dialogue, organized by the University of Belgrade Faculty of Law and the Serbian National Internet Domain Registry Foundation. Our successful cooperation with the Serbian National Internet Domain Registry Foundation started in 2015, when the first conference dedicated to the legal aspects of the Internet was organized. Since then, we are gathering every year to discuss the latest legal developments in the online world. Please allow me to thank our co-organizer once again, and also to thank the law firm Getzich Law, who supported this year's edition. This year, distinguished professors from Germany, Poland, Austria, Italy, Slovenia, Cyprus, Hungary, the Netherlands, China, and also from Serbia will analyze the rules governing online platforms in Europe, but also in other parts of the world. I wish all the speakers, chairs, and also those of you in the audience, grateful discussions. Thank you very much.
Thank you. And now we will listen to the welcome address by Dr. Dejan Đukić, Director of the Serbian National Internet Domain Registry Foundation.
Dobrodošli na Internet Dijalog, konferenciju posvećenu pravima korisnika, intelektualnoj svojini, privatnosti u organizaciji Pravnog fakulteta Univerziteta u Beogradu i Fondacije Registar nacionalnog internet domena Srbije. Ove dve organizacije već dugi niz godina organizuju konferencije koje se tiču odnosa regulative, pretežno intelektualne svojine i interneta. Danas imamo jedan širi fokus i pričat ćemo o privatnosti korisnika, odgovornosti platformi, takođe i jednom segmentu intelektualnoj svojini. Predstojeća nova regulativa koju donosi Evropska unija je nešto što će se u narednom periodu takođe i primenjivati u Srbiji nakon usklađivanja. Tako da očekujemo da ćete danas steći nova znanja koja će vam u budućnosti biti od koristi i da ćete ovo što čujete danas moći da primenite u budućnosti. Hvala.
Thank you. So, as Dr. Đukić mentioned, we have started organizing conferences, yearly conferences, with the Serbian National Internet Domain Registry Foundation in 2015. We have started with conferences dedicated to intellectual property law, and since 2019 we have started combining these conferences with conferences dedicated to other internet-related issues other than IP, and this is one of these conferences entitled Internet Dialogue. So you are aware that recently the European Union adopted the Digital Markets Act and Digital Services Act, and it is in process of adoption of some other sources which will be applicable to online platforms. So we will today explore these new regulations adopted by the European Union, and we will also analyze the comparative law aspects with insights into US, Australian, and Chinese legal system. So without any further ado, I would give the floor to the participants of the first session, and I invite them to join me here. Thank you.
Dear organizers of the conference, dear panelists, dear audience, good morning. My name is Ivana Stojanović-Raješić, and I am counsel at Gecić Law. Here we are today to discuss topics on the digitalization era that we're experiencing every day, that we're living every day. Some of us like, for instance, uploading more posts or photos online on various platforms, unlike others. Some of us prefer e-shopping because it's more convenient, better choice, more products available, and much easier than going around the malls to try to buy an item. Some of us would rather text a friend or send a voice message than seeing them in person. Again, it's more easier, convenient, or sometimes we feel like we're there all the time, real time. Some of us would opt for a quick search on the mobile app on some street, on the map for that street particularly, and looking on the phone rather than trying to recall where that street actually is. So the list is endless. We can find so many examples, and this is actually the new reality that we're living, and that our lives are actually dependent on online platforms. And it comes with a price tag. Us as end users, our rights may be breached along the way. Maybe the opportunities for business users can be limited, and they will not be able to contest them, and maybe competition law tools are just not enough. Therefore, the EU has come up with some new pieces of legislation trying to provide for or ensure more contestability and fairness for all participants, to boost innovation, because as we all know, innovation comes with or leads to better quality, better choices, lower prices, and then everyone will benefit from it. So here we are today to explore the main topics, the main issues stemming up from the new legislation in EU digital framework, to raise some issues, to ask some questions, to make some conclusions, hopefully. And then let's see how it goes. So the first panel, I will introduce the participants. I will try to pronounce their names correctly. We will be hearing from Professor Matija Damjan from University of Ljubljana, Slovenia, with his topic, the interoperability requirements for digital gatekeepers. Then we will have Professor István Horkoly, University of Szeged, Hungary, for the topic access to digital content on the digital markets, empirical pieces of evidence of the gatekeeper function of digital platform providers. Then we will have Professor Dr. Giacomo Tajuri, University of Amsterdam, the Netherlands, self-preferences, practices and their future after the adoption of the DMA. And finally, Dr. Giulia Schneider, Università Cattolica del Sacro Cuore, Italy. Stakeholder engagement in European digital regulations, ways forward, and possible drawbacks. You will all have 12 to 15 minutes for your presentations, and we will organize Q&As sessions after the second and the fourth presentation. Without further ado, I would give the floor to Professor Matija Damjan.
Thank you very much for this nice introduction. It also nicely allows me to skip the first slide, which, since you've already introduced us into the legislative package under the name of Europe Fit for the Digital Age. Now, my topic is the interoperability of the requirement, the interoperability requirements for digital gatekeepers, which have been introduced by the new European legislation. Specifically, these requirements stem from the Digital Markets Act. And the purpose of this act is basically to prevent the abuse of market power by the big tech, by the internet giants in the European digital single market. Whereas the Digital Services Act basically applies to all online services. The DMA is a sort of ex-ante regulation of the largest players in the market, usually American companies, that have the power to distort competition in the market. Now, what is the specific what is the cause of the huge market powers of the big tech in the digital environment? Is the fact that the way the internet operates today is through online platforms. If you're a company and you want to appear online, you won't just have your website, you know, or obviously you will have it, but you know, if the Google search doesn't find it or lists it on the third page of its results, then it's basically irrelevant that you have your website. You won't reach the consumers. So you need the search function to come in touch with your customers. And the same applies if you're I don't know, producing apps. They have to be available on one of the big app stores. If you're selling to consumers, probably one of the market online markets will be relevant for you. This kind of intermediary service is now called a core platform service. These are online services that serve as gateways for business users to reach end users. And the DMA lists the following ones: online intermediation services such as app stores, search engines, social networks, video sharing platforms, instant messaging, operating systems, web browsers, virtual assistants, cloud computing, and online advertising when provided by one of the providers of other core platform services. So not any provider of these services is regulated by the DM, but just the largest one, the ones that have larger, important market power in the digital single market, and this is defined the term digital gatekeeper. So these are just the big players. We should know them under this name now, are the ones that meet certain economic tests of their market power, which is measured by their annual turnover or market valuation, and then the extent of the use of their core platform service, which should have at least 45 million active monthly end users. The word active is missing here on the slide, but that's a very important part of the definition, and at least 10,000 business users in the EU. And this position should be entrenched and durable, so they must meet this criteria at least 3 financial years in a row. So a company that meets this criteria will have to notify about this to the European Commission, and the Commission will then designate it as a digital gatekeeper. And once this designation has been made, within 6 months the obligations kick in that the gatekeeper must follow. And the purpose of the obligations is, as I said, these are ex-ante rules, which means that we won't be waiting for the digital gatekeepers, the big players, to abuse their market power. We will have rules in place to prevent that from happening. So we will act. The EU is trying to act preemptively in a way, in order to protect whom? Businesses on one hand, the competitors. The new rules should also keep the digital market open for new innovators, new tech startups, and finally, the rules should also protect consumers by offering them more and better services, and particularly more opportunities to switch providers if they find another service better than the existing one. Now I'll make a brief overview of the new obligations under the DMA, and then I'll focus on the interoperability requirements. The list of the new rules is quite long. We can divide them in different ways. If we just list all of them, it's not quite transparent, and some of the rules are written in a way that you don't really understand them. You don't know what you're reading about unless you have already read beforehand what the purpose of the rule is. But I prefer the way to divide those rules into 3-4 packages by the subject matter. So the first set of rules, contains prohibitions of various unfair business practices in the widest sense of the word. So this includes self-preferencing in the ranking services. Self-preferencing means ranking one's own services higher than competitors. We'll hear more about that later. What else is prohibited? Forcing business users and end users to exclusively use the gatekeeper services rather than third-party services. And for example, requiring users to use a particular service or particular app and prevented them from uninstalling it. So the new rules should end the situation where you can't uninstall some apps from your phone, for example. A very annoying situation. The second set of rules concerns better data protection in digital services. This basically sort of upgrades the rules contained in the general data protection regulation and prohibits gatekeepers from processing end users' personal data, tracking them outside their main platform, and processing data for targeted advertising, again without users' consent, of course. And what's also important, dark patterns are prohibited, so the user's consent should not be obtained with manipulative design of online interfaces, but through honest and informed consent. The third group of obligations concerns increased transparency. We know that the operation of online services is quite mysterious for end users. For example, we have no idea how search engines operate. We still won't have an idea about that because their algorithms are a trade secret. But still, the pricing and fee systems should be explained to advertisers and publishers. Performance data should be provided by the advertising services of those engines. And for example, the general conditions of access to software app stores should be published. This is also everything under the headline of increased transparency. And now finally, my topic, the increased user choice is the aim that should be achieved through new interoperability rules. The basic requirement is that operating systems and the key hardware and software features should be, the ones provided by the digital gatekeepers, should be interoperable with third-party software and third-party hardware. So a very wide-ranging requirement, not formulated quite in this way, formulated in many specific requirements. So for example, an operating system should be compatible with different app stores so that you can choose apps from different providers. And as far as hardware is concerned, for example, we have an NFC chip, near-field communication. It should be compatible with various payment services, not just the one offered by the producer of this hardware. So it extends to both hardware and software. Now these are both Apple cases, but it will also apply obviously to other producers such as Google. Messaging services, we'll see, should also become interoperable. Now, the definition of interoperability, I won't read it. It's contained in the DMA. Interoperability basically means that software or hardware and software is designed in a way that it can work together so that all the functions and systems are operate in the way that they're meant to use, that they're intended to function. So it's a requirement that the design, that both the software and the hardware which the digital gatekeepers offer is designed in a way that it will be interoperable. The purpose of this rule in this competition context is to reduce network effects. If you know what the network effect means, it means that certain services provided to users increase in their utility for users with the increasing number of users that they're on. You know that a social network is more attractive when more of your friends are on it, and the more of your friends are on it, the harder it is to switch such a network or go to one where no one is on. The same applies to networking services, messaging services, and other network-related stuff, and obviously this hinders competition in the market. With interoperability, you could easily switch from one network to another, well, if you'll still be able to reach the users of the other network. The way this is achieved is through various technical means, either shared protocols, open APIs, application programming interfaces through which software apps communicate, or other technical solutions like data pools. Now we can speak of two sorts of interoperability, vertical and horizontal ones. Vertical interoperability means the interoperability of products and services which find themselves at different levels of the value chain or the product stack or protocol stack, which means that they're not directly, don't compete against each other, but they work together well, vertically. Examples are better. The compatibility between hardware and operating systems is one such example. The compatibility between operating system and multiple app stores, which I mentioned before. The compatibility between platforms and payment, different payment and identification systems. So we can stay on the same platform and use different competing services to provide certain functions on the platform. Horizontal interoperability means, in fact, something more. It's interoperability between products and or services at the same level of the chain or stack. For example, one that we already know and it's common is interoperability between email services. You know that it doesn't matter which email provider you use, you can always send email to any other user of email because it's based on a general open protocol. So it doesn't matter if you're with Gmail or Yahoo Mail or whatever other provider. And the EU is now trying to achieve something similar with messaging services, as we will see shortly. Now the requirements contained in the directive, here are three that refer to vertical interoperability. Operating systems should be designed in a way to enable the installation and use of third-party apps or app stores and setting them as default. Then end users should have the ability to switch between different apps, for example, to choose between iTunes and Spotify. And hardware and software features should also be designed in a way to be interoperable. For example, as I mentioned, the NFC chip should work with different payment systems. Another requirement that is connected with the interoperability is data portability. Obviously, if you want to switch a service, you want to bring all your data that you have created with one app to the other apps. That's the easiest way to ensure that the transition is smooth. So the regulation requires an increased level of data portability. And then we have the horizontal interoperability, which is interestingly something that was not contained in the original proposal of the Digital Market Act by the European Commission, but was introduced in the legislative procedure by the European Parliament. And this is this one doesn't apply generally, but just to what is referred to in the DMA as number-independent interpersonal communication services. These are basically the messaging services, the instant messaging, interpersonal messaging, however you should refer to it. Now, the basic functionalities of these messages should be interoperable. We know that they are not at the moment. We have the logos of some of the messaging services here. You probably know them. Currently, if you're in the system of one service, you can only communicate with the users of the same service. With this interoperability requirement, you should eventually, after a certain time, there's a timing for example, for group calls, which should apply later, you should be able to communicate with other users. Well, I won't go into details on that. The technical requirements are not contained in the DMA. This is something that we expect the providers, the gatekeepers, to develop themselves. We'll see if this works.
Sorry, just Just to remind you for the time.
I'm finishing. Just two concerns. One concern is how this interoperability requirement will affect the privacy. Now the huge advantage of the instant messaging services over email, for example, is that it provides end-to-end encryption and so a much greater level of privacy protection for end users. We don't know, there are serious concerns that this will be much harder to implement with open APIs or with shared standards. This is a technical issue, so it's better for me not to comment on that, but it may also introduce additional legal issues concerning licensing of open standards and so on. The other concern is in the competition of, in the area of competition law. Will this affect really will these rules really achieve their desired effect on competition? There's a concern that the horizontal interoperability might actually reduce the incentive of the users to switch between multiple services if they will all provide the same, basically the same functionalities for anyone. The European Commission stresses here that not the requirements for horizontal interoperability does not apply to all functions of such messaging services, but just the basic ones, so there will be still option to innovate and to offer new services. And this also is the answer to the other concern that mandated technical standards might also reduce competition and reduce the motivation for new players to enter this market. Well, that's the content of these rules. We'll see how they work. I had this conclusion, but we really don't know how the new rules will operate in practice. But I think we can certainly conclude that this will significantly, particularly when the messaging services are concerned, this will significantly also affect the user experience online. Thank you.
Thank you very much. We'll head to Dr. István Horkai, after which we will open the Q&A session.
Thank you. First of all, let me introduce myself. My name is Horkai István, or István Horkai, whether you like it, two ways. I'm coming from the University of Szeged and also representing my colleague, Professor Péter Mezei. And could you please pass me the presenter so that I can switch the slides? Thank you for closing your presentation with the user expectations and user experiences, because the topic I brought today is about user expectations and what users can do on the digital platforms and how their access and access rights are restricted by end-user license agreements. This whole story about the digital single market is not new. It has been going on since 2015, according to my best knowledge. And recently, Hungary was the second one implementing the CDSM directive. I'm not going to talk about the CDSM directive, but to introduce the topic, I have to highlight one fact. And this fact is that we conducted a 2+1 phase research with Professor Péter Mezei, and the research results are the one that I'm going to share with you today. So let's start with these two triangles. In the first, or in the left-hand side, you can see those triangular relationship that we are in the digital platform economy. This is the rights holders, online content service providers, and end users relationship. The two-sided marketplaces are basically connecting together the rights holders and the end users and other market players such as advertisers. If you take a look at the second triangle, I put some highlighted words on that. Every end user wants to get a full control access, full access to the content, which is obviously there if it is about physical, tangible, material copies. So if you have a book, you can read it, you can borrow it, you can lend it, you can burn it, you can do whatever you want with that. This is not the case with digital platforms. In the digital platforms, we have to face severe restrictions if it is about access to the content. And these restrictions are determined by the code itself. So what we have, for example, in case of Meta or Google or whatever platform we are using, they have a code. The code determines what we can do on the platforms. The other determinant factor are the end-user license agreement or agreements. We usually don't read them. Boring, confusing, hard to understand, hard to follow. We just scroll down, accept them, and then we can continue with the access of the content. But what we want is really a full access and full control over the content. So what we have, on the other hand, is a restricted, narrowed down scope of access right, basically. Whether we can label it as right or not, I leave it for the Q&A session. If you have comments on whether these rights, whether there are any user rights or such things. But what we have in the digital age is a different pattern of revolution, different level, different way of regulation. Because prior to the internet, the pattern was really simple. There was an innovative technology which transformed the market, and then the regulator created some regulation and everybody was happy. They were more or less following the rules. It has changed when the internet came, because the internet introduced an open space, a Wild West basically, without rules. And there was a question, who will regulate this internet Wild West? And of course, international legislator, regional legislator, member state legislator wanted to regulate, because obviously there's a principle which is called high level of protection regarding intellectual property. And obviously, in the digital space, this high level of protection was not really respected. But still, there was a need for regulation, and due to the fact that these platforms were the gatekeepers, the actual gatekeepers of the access to the content, and they had the technology, they had the code, they had the possibility to regulate, and they started to regulate on their own. And it led to the end-user license agreements. So let's talk about end-user license agreements. We participated in an H2020 Horizon Recreating Europe project in the last 3 years. And we did several researches in the field of end users, platform providers, GLAM sector, etc., etc. And in one of the research group, we analyzed 17, plus in the third phase, I added TikTok to the list, platform providers and end-user license agreements. And we wanted to understand the content of the end-user license agreement, and we wanted to identify patterns in the end-user license agreements. The first pattern was that we can put these platform providers into different groups. The first group is streaming with host service. So when they admit, when they promote user-generated content, which is a really, really important factor. In the second group, you can see streaming providers without host service. This is also important because they are making available contents that are already licensed. In the third group, you can see online marketplaces, and lastly, social media platform providers. And we looked into the details of the end-user license agreement. We found patterns. Let me start with the third group of patterns. In the third group, I was focusing on the territorial aspects of the end-user license agreement. And regarding territoriality, let's just get back to this map, basically. This is the map of the internet. Internet is borderless, more or less. Technically, I'm not a technical guy, so I don't know whether it is a true statement that internet is borderless, but the free flow of information, free flow of services is really borderless. So we can access websites from, I don't know, Antarctica, if there were any websites from Antarctica. So really, internet is borderless. But the end-user license agreements have something to say about the territoriality. First and foremost, they have some reference to the nationality of the service provider or the subsidiary. They have something to say about the appearance of the territoriality. It is especially true regarding streaming without host service providers because they are really keen on differentiating on a territorial geographical basis. There are references to the choice of law. This is important because if it is about content moderation and the content that we want to upload on YouTube is being removed, then there must be some ways to contest it. There must be some ways to try to come to an agreement with the platform provider. And there are rules in the end-user license agreement about the choice of law and the conflict of laws, which law applies for these end-user license agreements and to the service. And there are references to certain legal instruments of a legal system other than the European legal system. This is really, really important, that in the European Union, in the digital single market, the European legislator is keen on creating a digital single market in which the services can freely travel across countries. But, for example, if it is about geo-blocking, there are some restrictions, there are some geographical restrictions imposed by the platform providers on the content consumption. And most importantly, digital platforms that are operating in the European Union are mostly North American-based companies, which have European daughter companies in most of the cases, but they are coming from a different jurisdiction, a different copyright regime. A different copyright regime in the sense that they are Anglo-Saxon copyright regimes. Anglo-Saxon copyright regimes are slightly different than the European civil law-based authors' right regimes. And when it is about regulation, it is really, really interesting to see how these end-user license agreements are importing foreign legal instruments to the European legal system. For example, in the streaming with host services or online marketplaces or social media platforms where there are user-generated contents, when it is about content moderation, they usually refer to the DMCA, which is the Digital Millennium Copyright Act of the United States, or to the Fair Use Doctrine, which is also a copyright regime or an instrument coming from copyright Anglo-Saxon-based legal regime. So what is this if it is not a legal colonialism? And of course, obviously, there are some other relevant provisions referring to community, EU law, most of the cases, limitations and exceptions. In the first and the second phase, we tried to somehow measure the user flexibility and the user friendliness of these platforms. These are the variables which I mentioned, that there are some patterns which are repeating themselves in this end-user license agreement. First and foremost, the extent of the access rights, so what you can do on the platform. In most of the cases, watching, listening, access to the information, and that's all. Second, restricted uses. Now that's a way longer list, what you cannot perform on the platform. You cannot copy, you cannot make available to the public, etc., etc. Allowance of the UGC. License granted to the platform, other users over the UGC. This is really an interesting factor. Licensing of user-generated content on the platform. In most of the cases, the platforms are granting for themselves worldwide and most of the cases free license to use the user-generated content. So this is really interesting. Technological restrictions on access, family sharing or other types of transfer of content or subscription, or modification of terms and conditions and termination of agreement and procedural safeguards. When it is about modification, these are really end-user license agreements, which are general agreements, which you are not in a position as an end-user to negotiate. You accept them or you don't accept them, and you cannot access the content. And this is what we found out after measuring these variables. In Hungary, we are grading the students from 1 to 5. 5 is excellent, 1 is a failure. So you can see that Netflix, which is a streaming provider without host function, which means that they are making available content, already licensed content, and they are not hosting user-generated content. There is no way of interaction between end users or among end users. And as we go from streaming platforms without host function towards the social media, where there is a huge space for user interactions, the overall score raises, but none of them reaches the excellent mark. And finally, I brought 4 very dense, very detailed tables, which I'm not going to bore you with. These are just examples of how the end-user license agreement are regulating the territorial aspects of access to content. And last but not least, let me conclude my remarks with 3 statements or more or less observations. First of all, these private ordering mechanisms or end-user license agreements, in my understanding, behave like lex mercatoria. This term comes from the maritime commerce which means that there are independent self-regulating standards through which international and economic actors are interconnected. Secondly, these are global actors, and they have regulation for themselves. And these regulations act as a global economic constitutionalism, which means that there are self-regulating norms coexisting alongside the constitutional systems of nation states following the territorial logic through which international economic actors are interconnected. And last but not least, these contractual practices are transnationals in nature, transnational corporations and user license agreements, and they are autonomous regulatory tools that may extend across multi-jurisdictions. So thank you very much for your kind attention, and I'm open to any questions if you have.
Thank you very much. So I would like to open, to give the floor to anyone who would like to ask a question or have a statement with regard to these two presentations. Thank you. Yes, please.
So I have a question for each of the presenters. First, for Professor Damian, I was wondering, I mean, you already started to kind of, hint at the question of, well, I mean, these are rules and it's kind of, nice to study the rules, but there is a kind of, second element to that, which is, are they able to be applied and through what kinds of remedies? You mentioned that there is a kind of technical difficulty in achieving some of the objectives that are there, but there are also some legal and enforcement ones, and I was wondering if you could comment on, whether you think that, this kind of programmatic statement of these pieces of legislation is actually achievable for any regulator through legal enforcement and remedies. And for Professor Horkai, I guess my question is about your last slide, where you sort of seem to, you have these three, let's say, ways of organizing the rules that you are seeing in the agreements, and then you have kind of like, arrows between them. But I'm not sure whether you're suggesting that there is some kind of a hierarchy between these, whether one influences the other, or whether they're just operating in parallel without actually talking to each other at all. Thank you.
Yeah, let me start. I think, yeah, the question is a very good one, of course. But I think that the aims and the values of this legislation are, in a way, so vague that I'm sure that the European Commission, after 5 years or 10 years, will declare that they were a great success and everything has been achieved, whatever they wanted to. Unless they'll want to introduce some new regulation, then they'll find that there are problematic practices still present. Really, the aims are very vague. I mean, I'm sure they are achievable, precisely because we don't have technical specifications in the regulation itself. So it will be up to the gatekeepers themselves to find the solutions. And I guess this will go through a certain process of negotiation. Is this enough if we do it this way? And in a way, they'll have to self-regulate themselves, lex mercatoria, but a regulated one under the control of the oversight of the European Commission. So this is how I expect this would work. I really mean that the rules will still have to develop in practice before we know what they are, for example, in technical terms, and which will also bring additional legal issues, such as if we choose open standards and the licensing of such standards and so on. So, yeah, I think it may be achieved in this way.
Okay, so answer very briefly, all the fault goes to the PowerPoint presentation program because it offered me this way of structuring my argumentation. But in my understanding, there is no hierarchy regarding argumentation. But obviously, if it is about legal resources and legal environment in which these platforms are operating in Europe, there are hierarchy. European norms, member state norms, and then should come the platform's norms, the platform regulation. But what we see is that they have higher influence over the access to the content, over the regulation, and that they are somehow not really keen on implementing properly the European norms. And this is especially true regarding the complaint and redress mechanisms which are imposed by Article 17 CDSM directive. It was interesting to see that only YouTube and TikTok, interestingly, were the ones that expressly mentioned that there are existing copyright norms in the European Union, limitations and exceptions, parody, pastiche, etc., which must be implemented in the end-user license agreements as well. Users can rely on them, users can refer to them when it is about content moderation. So that would be my brief answer.
Yes, please.
I have a question for Professor Horkoy. Obviously, your last slide will only work if you accept unlimited choice of law. In working on your study, did you have any empirical data, how national legal orders are happy with the current licensing agreements?
Could you please rephrase your question, because I didn't really get your point.
My point is that your last slide obviously relies on free choice of laws. Mm-hmm. Now, this will only work if national legal orders are happy to accept free choice of laws. Mm-hmm. If this doesn't work, then basically the slide is an object for future discussion. And now my question is, do you have any legal empirical data how these licensing agreements that operate on free choice of laws are accepted by courts or national jurisdictions?
Mm-hmm. Okay, what I have as an empirical data is what's stated in the end-user license agreement about the choice of law. And in most of the cases, the law that is applicable is the law of the host country, either as the mother company or the daughter company. So for example, in the case of YouTube, Google, which have a daughter company in Ireland, the applicable law for Irish citizens, for European citizens, is the Irish law. But there is a difference being made between end users or among end users. If the end user is located in a third country jurisdiction, in most of the cases, the law of some of the American states will be applicable. So in most of the cases, California or New York State is applicable. Federal law, state law. When there is a daughter company operating in Europe, then the European norms will be applicable, but only indirectly, because I couldn't find any reference directly to the European law regarding the applicability. It is always stated that the host country's law will be applicable. And if it is about Irish law, then indirectly the European law also applies. And in one of the platform providers that we analyzed, the biggest adult content provider, or one of the biggest adult content provider, has a headquarter in Cyprus. And in that case, the law of Cyprus is applicable. But there is no reference directly to the European law, only to the member state law.
I'm sure if you have a system of a conglomerate, you have parent companies and you have subsidiaries. Within this conglomerate, you will have unitary standards. And obviously, these unitary standards may be in potential conflict with the national law of one country. And this is not exactly a choice of law problem, but still it is a problem of diverging legal orders.
Mm-hmm. Yes, I understand your concerns, but our focus was not particularly on international private law aspects. The choice of law was just one indication how the platforms are dealing with territorial issues. And this is especially important when it comes to content moderation and debate between the platform provider and the end user, because due to CDSM Article 17, there is a filtering obligation on content providers. And if a content is being filtered out, and that content is a lawful content, there must be some kind of complaint and redress mechanisms. Or if there is any other debate between the platform provider and the end user, there must be some way to resolve this conflict. And we try to locate those signs of territoriality or any signs which are related to territorial aspects. And Joseph Law was one of them, which indicated how these end user license agreement and the platforms are dealing with the territorial aspects, and the very fact that they are multinational companies providing service is not in not only one member state or not only one state, but in globally, basically. Yeah.
Thank you very much. I would just extend to Professor Damian's presentation just for a quick comment on the major issue that comes with interoperability that I have come across with the opinions of academia and experts, crypto experts and practitioners is about how it is going to be made in practice with the encryption, with the sharing of these encryption codes, and how it is going to be, whether it's going to be feasible or not with a time frame set by the Commission, and especially then a quick question, would there be standardization actually possible and possible in any time soon? What do you think?
Well, that's basically a technical issue. It's better for me not to comment on that. I agree that the time frame seems quite short. I mean, 6 months for the first obligations and then 2 years for additional ones, but I can only speculate on that, whether the technical solutions for this already exist and they just have to implement them, or this is something that really needs to be developed newly. It depends on that pretty much, I guess. But one interesting issue concerning this is that that we're addressing this competition issue in the field of instant messaging, and which will bring these huge issues. Although we have seen that this is a particular part of platform services where competition already exists. We have several competing strong players in the market. So it's interesting that it's precisely this where the EU has decided to act.
Let's see how it develops. Thank you very much. So we will pass on to Giacomo Tajuri, please.
Thank you very much. And I take this. Do I have to turn on the mic or not? No.
I don't think so.
Okay. So thank you for having me here. I will talk about the meaning, what does it mean, this notion of self-preferencing in the DMA, and I will use self-preferencing and the self-preferencing prohibition to reflect a bit more broadly about possibly the goals of the DMA and its functionalities. Let's start by, and here sort of my interest is mainly on Amazon, but today I will reflect, and let's say commerce and e-commerce, but I will reflect a bit more broadly. What does self-preference mean? Which practices attract the label of self-preferencing? The most prominent one that most people will have heard about is the one of Google Shopping, the EU Commission case, which was basically confirmed by the General Court, whereby Google was found to be favoring its own price comparison servicing on the search results. So its own price comparison service, Google Shopping, was shown more prominently on the search result, where there should have been, let's say, competition with other price comparison services. This, of course, is a feature of Google being a vertically integrated or an integrated company which offers the search services alongside other complementary services, including the price comparison service. Another platform that has been suspected, and there is pending investigation to self-preference, is Amazon. Amazon operates the marketplace, but also sells its product on the marketplace, especially with the label of Amazon Basics. And the Commission is investigating these practices with the idea that Amazon favors its own product on the search results. Again, Amazon is a more traditional case on vertical integration. It can be seen as a sort of online mall in a way that hosts other shops, but also has its own shop. Finally, concerns have emerged around the app stores, Google Play and the App Store, especially in a moment in which Apple has started to produce more of its own apps. So at some point there was reporting that if you Googled music or podcast, the first 7 or 8 apps coming up were all Apple apps. And that would be an instance of self-preferencing. Self-preference may not manifest only through ranking. In the app market, there is a preoccupation and investigations that actually the very high fees that are charged to third-party developers of apps may itself constitute an instance of self-preferencing, because Apple, of course, doesn't have to pay those fees on its own apps. Again, this, I think, can be seen as a sort of rather standard case of a vertically integrated company where Apple provides the Apple Store, but it's also a producer, a seller of its own product on the store. So based on this example, how can we conceptualize self-preferencing? I think self-preferencing is a feature, depends on the fact that providers of two-sided platform or intermediation service vertically integrate somehow. And there is different emphasis. Some scholars emphasize very much the vertical integration. Others emphasize very much instead there is a complementarity of service, the multi-sidedness of markets. There is not agreement on this. But generally, I think there is, and that's to understand it, we need to understand this element of vertical integration. And I think it is a pervasive feature of distribution and commerce in the digital economy. It seems to happen to some extent in all of our activities of commercial and consumer life in the digital economy. Although the problem is not new. When you start reading about self-preference, you immediately find a comparison very explicitly with supermarkets starting to produce their own labels. So supermarkets at some point also vertically integrate. They go into production. They have their own labels, own branded product, and typically these are shown more prominently on the eyes of the supermarket, which would sort of be also an element of self-preferencing. Again, to conceptualize it, and I think it's a helpful conceptualization, there is the idea of a dual role of the providers of platform services. This is really, it's a language that we find in the DMA and also informs the previous investigations under 102. It's the language that the Commission uses for the Amazon investigation. Dual role, again, it means that the platform provides and operates the platform, which is some form of intermediation service, but also offer their own product and services on the platform. I think to fully understand this, we may need to add more roles that are at play, which is by organizing and by providing the platform service, the platform is also a designer of the market and, to understand, a regulator of the market. So they determine to some extent, together with regulation, the rights and duties of the business users and the consumers. And here, I think it's how you understand this type of language, which has been circulated, especially in the US, with Senator Warren saying you don't get to be the umpire and have a team, so you don't get to be the referee, impartial, and have a team. If you're designer of the market, then you cannot really sell your product. There was this sensitivity behind the investigation. And also prominent to understand what's happening is the use of data. Again, especially in the Amazon investigation, the sort of perceived problem and sense of injustice had to do with the fact that Amazon developed its own products thanks to the collection of data from the business users. So the shops took the risk of developing a new product, and Amazon basically copied the best-selling products. That is the charge, at least, that has driven the investigation of the Commission. So what happens with the DMA? The DMA relies on all of this experience of enforcement. Some of it has been completed, like Google Shopping. Some of it is pending, but relies on this experience to develop an explicit prohibition. And I apologize here. I'm embarrassed. There is the wrong article. It's 6.5. It's not 6.4, which I said. So explicit DMA self-preferencing prohibition we find in Article 6.5, and this is the text of the prohibition. Gatekeepers cannot treat more favorably in ranking and related indexing and crawling services and products offered by the gatekeeper itself than similar services or product of a third party. And then there is this addition that says the gatekeeper shall apply transparent, fair, and non-discriminatory conditions to such ranking. So I'll say a few things that are rather clear and uncontested about the formulation of this prohibition, and then I will reflect on sort of what we don't know and what we need to figure out to sort of apply the prohibition. So first of all, this is a form-based prohibition as most of the language, at least it's framed as one. So it's not about the effects, unlike competition law, it's some things that the gatekeeper should refrain from doing. As I'll show, there is still, I think, meaningful uncertainty whether equivalent forms of conduct should be prohibited, and I think they may, like forms, like, I don't know, pricing practices. We'll say about that. So, of course, it's grounded in the wisdom from previous investigations, but I'll say something more about that. I don't think the application of the prohibition should be constrained by these previous investigations. Finally, I think the text is really framed, I think, on search. That's, I think, what they have in mind when they use this language, ranking and related industry and crawling. But the recitals of the DMA are explicit that this applies beyond Google and search engines. It applies to App Store, e-commerce, social media. Indeed, actually, the Commission has also opened somehow self-preference investigation under 102 against Facebook Marketplace. So also social media is now part of this. Finally, in terms of the first, let's say, interpretative hurdle where there may be some disagreement is this notion of distinct or additional services. So the services that are preferred or treated more favorably, of course, cannot be the same core platform service. This is about vertical integration. So it needs to be a distinct or additional form of core platform service of the gatekeeper. Recital 51 says this needs to be distinct or additional in the view of the consumer. So it needs to be perceived as a separate service by the consumer. And here I think you already see in the debates that are happening how this may be going, because companies insist that you cannot really distinguish, and it doesn't make sense to talk of vertical integration, that there is an ecosystem and different functionalities so that these systems, these services may not really be distinct or additional. So you see a bit of these arguments being laid out already. And then you also have an important idea. So self-preferencing doesn't only happen after the query by the consumer, but it may happen at an earlier stage when the search engine sort of crawls or indexes, you know, which in my understanding means it surveys the pages that are out there, the offers that are out there, and it organizes them to then show a result to consumer. So self-preferencing can also happen at that early stage. Finally, there is this duty which is attached to that. The gatekeeper shall apply transparent, fair, and non-discriminatory conditions to such ranking. I don't know if that's a general additional obligation for all rankings. It seems it is. The recitals of the DMA explicitly refer to guidelines that the Commission adopted in the context of the platform to business regulation. So there is here an interaction between a very related regulatory regimes on which there is already some experience. In terms of problems, interpretative questions that are out there in the debates. So there is a question whether this prohibition should also outlaw conduct which is just vis-a-vis business users. So for example, if in its interaction with business users, Amazon favors its own payment services, its own fulfillment services, for example, in the ranking, should this be prohibited? There is a debate on this, because this, in a way, may be outside of what the Commission had in mind, because it doesn't produce a manipulated ranking for the consumer. So the consumer here would still see a ranking that's okay, but there may still self-preferencing happening on the business side. and this would be a different case than Amazon Italy case. So the Italian Competition Authority fined Amazon because Amazon was favoring its own fulfillment service, but through manipulation of the ranking for consumers. So the business users that used Amazon fulfillment service were advantaged on the ranking. So this would be a different case, and I think it is included, but there is still a question of all of the things that happen on the business side where they're included. Another interesting debate that's unfolding is whether the prohibition also would apply to pricing conduct. For example, the excessive prices of the apps in terms of access fee or in terms of the 30% commission, can they be conceptualized as some form of self-preferencing? And finally, I think very importantly is, will companies have the ability to show that, for example, when they get the first or second position systematically, will they be able to show that this is a feature of an organic feature of the algorithm that serves the consumers and that is not self-preferencing, or is the form-based prohibition such as that they really shouldn't be in that position? That's, I think, a fundamental issue. Now, I see already I'm running out of time. I had some more things to say about how this maps onto the goals of antitrust. Well, I was going to say through suggestion that self-preferencing is paradigmatic of the types of concerns that drive the DMA. So in a way, we could think about what are the concerns that drive the previous enforcement on self-preferencing, what do they tell us about self-preferencing, and that can tell us something about the DMA. I think it's a bit of a circular reasoning, but it may be helpful, right? You know, because as you said, it's so vague, the references to contestability and fairness, that maybe looking at this previous enforcement practice can tell us something about what the concerns are. And then, of course, which is, I think, related to what Julia will talk about, there is features about the processes in the DMA, what we ask from companies, for example, in terms of compliance report, that also give a sense of what is the underlying rationalities and goals of the DMA. So if we understand these things, we can then maybe have a better way to solve these interpretative issues about the various prohibitions, including the self-preferencing prohibition. Very briefly, on goals, I just had a list of goals here. And there is more conventional antitrust concerns for competition and competitors that are typically framed in the language of foreclosure or leveraging, which means extending dominance from a market to another. And already in the Google investigation, there was a concern that this would reinforce dominance on the core platform service. And I think this is very important for the DMA, which is ultimately the contestability they talk about is contestability for the core platform service. Of course, this also harms consumer. And I think here I want to emphasize there is a product quality problem, and which the concern for the manipulated ranking, I think, is also a concern from the product quality. And we see it reflected in the remedy, which is, again, a remedy about changing the product design. In Google Shopping, it was that type of remedy. So you need to offer consumers a different interface. Consumer protection associations like BEUC are stressing very much of this, that the remedies and the solution are largely consumer interface design based. And then there is structural concerns. For example, some of the decisions of their preference, in particular the Italian one, has been called by some commentators the first neo-Brandesian decision in Europe. So this was interesting. There was a sense that, you know, we were shifting away from efficiency concerns into more structural or concerns about the concentration. I'm running out of time. I want to say just, here I had some concerns, but it's too much. So I think the DMA, so, you know, some people may say, well, that there is some form of harm to competition has been certified by this investigation under 102. The DMA just makes it easier to catch the same harm that we know is there through this sort of form-based ex-ante approach. I think this is a bit of a narrow interpretation. I think the DMA could be doing something more, and you need to see DMA has this sort of hybrid third-way nature that some commentators, some scholars have done, which, you know, of course, DMA doesn't only embrace platform neutrality as the solution. So it insists on contestability. So it doesn't simply say we regulate the platform, we make it neutral, and we keep the platform as uncontestable. It also doesn't simply embrace the decentralization and neo-Brandesian sensitivity to say let's break up. I think there is this sort of assemblages of interest that I tried to include before. And for example, product design, I think it's something that we will need to pay very close attention to. Product design, why? If you meaningfully design the interface so that consumers have some choice, this not only protects the business users, so there is an element of fairness, but also creates the precondition for undermining platforms' gatekeeping role. And this is explicit in some of the recital of the DMA, that this is the functionality. So I think if that's what we have in mind, I think the DMA is doing something more than just making it easier to enforce Article 1.2. I'll stop here, and maybe in the questions I can say something more if there's time. Thank you.
Thank you very much. And now we will go to Julia Schneider, so please.
So thank you very much. First of all, thanks for invitation, and thanks for the previous speakers for opening up the floor for the discussion this morning, which I will sort of close this morning's session with some more conceptual thoughts about the systemic contextualization of the new digital regulation, namely the DMA and the DSA, within the broader evolving European regulatory system. And in these terms, I'd like to question here the stakeholder engagement tool as a regulatory tool for digital platform and for the digital ecosystem. And in this slide, I wanted also to, my question here is to think about the possible also qualification of the DMA and the DSA in the frame of sustainable business rules. We know that in the context of business law, there is a strong push towards the consideration of more sustainable business conducts, which upon the substantial level relate to the consideration and the balancing of societal interest versus economic interest. And at the procedural level, this comes along the sort of request to establish more dialectic form of organizing business intervention. And in this slide, my question here is, first of all, to see and to map the approaches that the DMA and the DSAs are performing in respect to the consideration of third parties' interest, first of all, from the perspective of the very objectives that Giacomo has already put on the table of the DMA and the DSA, and then looking of some two possible approaches for stakeholder engagement that the DMA and the DSA propose, first of all, in terms of regulators' engagement. And then I want to ask whether in the DMA and the DSA there is and there are already some possible rules regarding also third interest parties' engagement in the form of a creation, so of a shift from the regulation of market power to the creation of some eventually counter powers to these big digital platform, exactly through the form of a dialogue. And in the conclusions, I'll give some critical notes on this regulatory tool in the form of stakeholder engagement. But let us start with the very objectives now. Is stakeholder engagement as a regulatory technique justifiable under the objectives of the DMA and DSA? Well, contestability and fairness have already been evoked, but looking at the definition of contestability and fairness in the DMA, we come along this instant of creating a dialogue. Contestability, if we look at recital 32 of the DMA, is not only about enabling businesses to enter the market, it is not only about the protection of a sound competitive process on the market, it is something more. It has to do with the preservance of innovation through the contestability on the side of businesses, but also, as the recital says, also of challengers and customers, which are interested and which may be eventually affected by a decrease in innovation if these potential interests and contestability would not be preserved. And exactly, if we look also at an extra-normative definition of contestability, we exactly see that contestability means not only engage in competition to attain a specific position of market power, but it has also to do with the ability to oppose, thus not only on the side of competitors, but also eventually on the side of third eventual interested parties. This idea of ability to contest, this ability to dialogue, is also enshrined in the notion of fairness that recital 33 of the DMA sort of sets. And it's the idea, the notion of fairness is, of course, related to market imbalances and to the ability to adequately capture, as the DMA says, the benefit resulting from the innovative process. And also this notion of fairness exactly hints at the idea of being able to be part of the process, in order exactly to prevent not only innovation sort of stops, but also fairness in terms also of protection of the potential adversarial impacts on societal and economic broader interests. Let's move to the DSA. In the DSAs, we do not have these overarching objectives. We rather have this idea of the fact that digital platforms have to ensure that their business models, their business activity, do not cause any systemic risk. And the DSA proposes 4 categories of this systemic risk. First of all, dissemination of illegal content. So we have this idea of protecting IP rights. Then a second category of rights, broader intended, is the idea of protection of fundamental rights. Then we have the third, systemic risk, and we can say systemic societal interest that the DSA takes into consideration, which relates more on the democratic processes, and this is also related, of course, to this core idea of ability to dialogue, ability of expressing ideas. And then we have a fourth category of systemic risk, which majorly relates to the idea of protecting vulnerable groups. Well, in this, along these statements that we can derive from the DMA and the DSA, we can surely notice that contestability, fairness, systemic risk can be considered as proxies of the broader notion of digital sovereignty and digital citizenships, which are not directly referenced to by the DMA and the DSA, but these are primary notions now in the regulatory agenda, which exactly refer to this idea of bringing back control onto digital platform, of being able, the idea of citizenship, to protect fundamental rights also in the digital space vis-a-vis digital platforms. So in light of this reading of the DMA and the DSA, we could conclude, we could advance the idea that both the DMA and the DSA sort of entail legally mandated obligations for digital platforms to balance economic interests with third-party interests exactly along the lines of a sustainable digital business. So from a substantial level, we can be sure that these third-party interests have to be acknowledged, have to be protected by digital platforms. Of course, the question comes along about how this can be made. And this question about the how, the methodological level and perspective is a bit more critical if we think about the structural features of digital markets, which relate to the complexity of business relation in respect to digital platform, the unpredictability of business in a fast evolving innovative landscape, which comes in turn along with contractual incompleteness, which is very difficult to manage also in terms of pre-identifying which type of interest, which types of third-party interests have to be effectively considered, the type of potential damage which may come along, the moment of the damage, if we think also about the long-term perspective, that this idea of sustainable business conduct brings about, and also the quantification of damage. And in this slide, it is the sustainable market regulations that now are coming up. The proposal for a sustainable due diligence directive is being currently discussed by the Parliament in these days, entail and propose this idea of stakeholder dialogue as a means of concretely identifying on a case-by-case level the concrete interest involved. And so my question here is, to which extent do the DMA and DSA enshrine this idea of stakeholder dialogue, of stakeholder engagement? And in this frame, we can conceptualize two types of stakeholder engagement in digital regulation. A first one being related to regulators as stakeholders in the regulatory process, and a second, more complex, related to third affected parties as stakeholders of businesses, organizational and governance choices. The DSA in particular makes reference to the problem of the design of algorithm. And so in this slide, let's turn to the first approach regarding stakeholder engagement in the form of regulators' engagement. So we know that the DMA, as also Giacomo was pointing out, the DMA is an hybrid form of regulation. It tries to balance the trade-off between flexibility and certainty along the lines of a semi-flexible option, which involves, first of all, a combination of quantitative and qualitative criteria to designate provider of core platform services as gatekeeper. Then we have directly applicable obligation, including some where a regulatory dialogue may facilitate their effective implementation. And then at the third level, we have a possibility for the European Commission to update both the obligation and the designation of gatekeeper through market investigation mechanism. And this market investigation mechanism, we can refer them exactly also as a form of regulators' dialogue, which has to be found in first hand in respect to the Article 4, the review of the status of the gatekeeper, where paragraph 3, we have this requirement for the Commission to regularly also review whether the gatekeepers continue to satisfy the requirement, and the Commission shall also examine also whether new undertaking providing new platform services can be qualified under the gatekeeper list and can be included. And then there is this idea also that the regulators may enlarge the obligations under Article 6, and this process also implies a dialogue with interested businesses. Indeed, a gatekeeper also, as paragraph 3 of Article 8 says, may request also the Commission to engage in a process to determine whether the measures that the gatekeeper intends to implement or has implemented are effective in achieving the objective. So we have really this idea already emerging in the DMAs of a sort of regulatory sandbox, as also already the proposal for an Act proposed the fact of a controlled regulatory environment, which also in a sectoral at sectoral level also the DLT pilot regime is proposing. But to looking at
soon wrap it up,
yeah,
since we will have to
absolutely.
Yes,
so this idea of regulators dialogue can be found also in the DSA, where Article 33 in respect to providers of online platform, exactly as the DMA does, also requires the Commission and entrusts the Commission of the possibility to enlarge in the list of core platform services, not only upon quantitative standards, but also in light of more qualitative qualitative standards, taking into account also market and technological development. Now, the question here, but I leave it also for further discussion, is whether we can find, apart from regulators' dialogue, apart from this idea of regulators' engagement in the regulatory process, whether we find also some rules regarding third stakeholders' engagement or directly affected parties' engagement in the idea of creating counterpowers of digital platforms, of large digital platforms. This is exactly what Recital 90 requires when it says that providers of very large online platforms should ensure that their approach to risk assessment and mitigation is based upon the involvement also of representatives of recipients of the service, representatives of groups potentially impacted by their services, independent experts, and civil society organization. Now, this programmatic objective, which is enshrined in the Recital, finds no direct, we can say, direct concretization in the obligations of the platforms. We have only in Article 16 this obligation for providers of hosting services to put and to enact mechanisms to allow any individual or entity to notify the presence on their services of illegal content. So we have this idea of dialogue also and of reaction with interested party in respect to the IP realm. And Article 35 also commands a direct cooperation with these groups which are known and are identified as trusted flaggers. But beyond these specific provision, we are not exactly moving from, or already in the DSA, from this idea of individual rights to this idea of collective rights and group-based digital sovereignty that the Recital 90 sort of expresses. And so this is a question also whether further regulation will open up to this idea of counterbalancing big market powers through not only regulation, not only direct obligation, but also through the establishment of direct powers in order to objectify these programmatic objectives regarding contestability and fairness in digital markets. Of course, the possible drawbacks of these mechanisms are, of course, the risk of stakeholder washing, so which are the criteria for identifying and giving precedence to specific groups, and also the risk of contestability of taking decision, so which are the mechanisms, exactly as Article 70 suggests, of involving, of enacting, of rendering this stakeholder dialogue possible. And this, just a very last remark, maybe the technological development of other markets, for example, other business sectors, also in the financial sectors, could give some suggestion regarding this in terms also of the potential that blockchain technology, exactly with this decentralized application and governance opportunity, can bring about also to solve some of the possible drawbacks of this idea of moving from a decentralized regulation related to regulators' involvement to a decentralized governance in digital regulation. Thank you.
I would like to thank all the panelists for insightful presentations and comparative analysis that we have witnessed today, with all the questions that were raised also. There is always a little time when the discussions are so interesting, so I would like to ask you to continue with any possible questions during the break. I apologize, I saw some hand over there, but if we can go on with during the break, because the next panel is about to start in, I think, 15 minutes or so. So thank you very much once again.
So you must be the second scholar from Białystok.
Yes, yes, I am.
Well, ladies and gentlemen, it is still good morning, and it's already Dobar Dan. Welcome to the second session. This second session is a session full of cooperation, so to speak. We have two cooperative papers, one from Białystok and the other one from Cyprus. And then we have the two co-editors of the book to come sitting on the panel. The first speaker is Dr. Magdalena Knapp from the University of Białystok, and she's going to speak about moving towards more transparent online platforms under the Digital Services Act. Before I hand over her to the floor, let us just say we are going to have two presentations, then we're going to make a break for the first round of discussions, and then we continue. Dr. Knapp, you have the floor.
Thank you for the kind presentation. I have the pleasure. Okay. Thank you for the help. I hope you hear me okay. So I have the pleasure to open the second session. I will be speaking about Digital Service Act, and I will be presenting on behalf of our two-person team that consists of me and Professor Anna Piszcz. We prepared this analysis for the paper, for the book that will be edited by Professor Popovic on my left and Professor Kuntz on my right. And it will relate to the obligations, due diligence obligations, relating to transparency of online platforms. So I will present the preliminary findings of our analysis. I will build a lot on what was said in the first session, but I will focus mainly on Digital Service Act, which is an unprecedented initiative in EU regulatory framework, as it tries to provide the rules for a safe and transparent online environment. And this is what you will hear in a public debate. Right now, in the digital economy, information is the fuel. And the information, the vast aggregated data by online platforms are at the core of their business model. That's why they're increasingly more important, and that's why we need some safeguards to provide the right protection for fundamental rights. DSA builds a lot on e-commerce directive and many other acts that were enacted many years ago and couldn't foresee how technology will develop and how the situation will change. That's why we also need this act. It tries to regulate social media, but also so much more. It relates to access to data, privacy, accountability of online internet providers. And most of all, the topic central to this presentation, so the transparency. We try to analyze the provisions of DSA that are relevant to the transparency. And specifically, we try to classify those obligations into two groups that you will see later on. The research method we used was linguistic analysis of the legal text, so we focused not only on the keywords available in the directive, but also the substance of the obligations. The analysis is focused on the perspective of recipient of the services, and I try to provide the list of the whole recipients. This will be consumers, business users, and other users. Of course, consumers are central to the whole public debate of what DSA is about. So we focus a lot about right to transparency, including consumers' right to transparency, because this is the most vulnerable user compared to business users, which are the professional party that have their own due diligence obligations. And other users, here I would say it consists of entities like foundations, associations, and other non-profit entities. When we looked at the obligations related to transparency, we identified them by keywords such as transparent, clear, comprehensible, easily accessible, publicly available. Those were the keywords that indicated that this obligation might relate to transparency. And as to the addressee of the obligations, we focused on specific group, namely online platforms. So if you see at the Digital Service Act, it encompasses 3 categories of providers of intermediary services: merconduit, caching, and hosting services. That was also explained in the previous session. And within the hosting services, we have 2 definitions. Definition of online platform, that would be the hosting service that, at the request of the recipients of the service, stores and disseminates the information, and that would be the 2 central activities. It disseminates the information to the public, unless this activity is minor or purely ancillary feature of another service, or a minor functionality of the principal service, and for the objective and technical reasons cannot be used without that service. This is the definition provided by Digital Service Act. And on the other hand, we have a very large online platforms, which will be the online platforms that have reached a certain threshold, a threshold of number of average monthly recipient of the services in EU, and Digital Service Act sets this at the level of equal or higher than 45 million of active users. That is more or less 10% of EU citizens. And of course, it will be adjusted accordingly by EU authorities whenever it changes. What you see on the slide is a designated very large online platforms. This decision is fairly new because it was enacted on 25th of April 2023. It's another step in entry into force of Digital Service Act, and I will give you a moment to look at it. In the meantime, I will say that, as you see, most of the platforms are American-based. We have few that are Chinese, and almost none that EU. So this is also important for a EU framework. Of course, what is also important to stress that DSA addresses also other parties. Many obligations relate not only to online platforms, but also authorities, so regulators, trusted flaggers, and many other entities, but we will focus only on online platforms. And as I said previously, we try to look at the goal of the obligations, and 3 goals are very apparent. So first is to achieve transparent online environment and achieve safe online environment. We focus mostly on the transparency, and some obligations also have in mind both goals. So they provide safe environment, but also transparent online environment, but also always transparency implies safety. When we look at the substance of the obligations, here we try to classify them into 2 groups, the so-called primary obligations, so the main obligations that online platforms have to comply with, and so-called meta obligations, that's how we call them, they're the second tier. So that would be the obligations where that would be the situation when online platforms are accountable for fulfilling the primary obligations. So it is to provide responsibility and to demonstrate the compliance with the primary obligations. So from the perspective of recipients of the services, right to transparency that can be derived from the right to information, so one of the fundamental rights, is correlated with those following primary obligations. This is just a few from the long list provided by Digital Service Act. And some of them are clear just from the name, but I will try to provide you a short overview. So online platforms are obliged to designate points of contact for recipients of the services. So this is to provide a two-way clear communications for all the users. I'm sure we all know this problem when we try to contact the platform. Usually it's especially a problem of smaller platforms which do not have this contact form, or it's not working, and it's completely automated. So this obligation also says that platforms have to provide for the human contact or human supervision of those automated answers. Whenever you're interacting with the chatbot, it also has to be clearly indicated. Another very important obligation is to provide user-friendly terms and conditions. I'm pretty sure that everybody who sits here at least once in a lifetime clicked "I agree" without reading. And I think it's more often than once. We just don't read those terms and conditions because most of the consumers are just anxious about the legalese, about the long terms and conditions that are impossible to understand. So with this obligation, online platforms have to be very clear and transparent about how the platform is working, how it's going to function, and everybody has to understand it. Also, very large online platforms have additional obligation relating to this one, because they have to also provide the summaries of those terms and conditions and provide them in the official language of the country where the service is provided. Another obligation, no dark patterns. What is understood by dark pattern? Another situation from life. Imagine you want to change the privacy settings, and then in the online platform you have to go through many screens. The decision mechanism is very complicated. The platform is asking you multiple times if you agree to this, if you agree to this. This is the so-called dark patterns, which kind of force you or try to make you some kind of decisions. So there is a need for additional transparency in the interface of the platforms. Another obligation, internal complaint system. Again, for me, it's very much connected with the first obligation, where there is usually a problem with filing complaints because it's an automated system. It's very much arbitrary. So there has to be more transparency. Two obligations, no ads micro-targeting, and recommender system. I will provide you overview two of them. So imagine this situation. You're talking with someone about the latest clothes that you want to buy. You search for them online, and suddenly all over your social media you see the ads relating to the very topic of that conversation. It's not transparent how it works right now, but when these obligations will come into force, online platforms will have to provide information on information that are ads, who provides them, who pays for them, and why are you shown this ad, this specific ad. And of course, recommender system transparency, we all live in information bubble, and this is thanks to those recommender systems. So the user will have a choice to opt out of this system or to stay. And the meta obligations that follow the primary obligations relate mostly to reporting. So we have transparent reporting obligations where is a periodic obligation where online platforms will have to publish the reports on how they are fulfilling the primary obligations. Risk assessment, it was mostly briefed by previous speaker from the first session. So I will skip to the independent audit. And compliance officer. So online platforms have to conduct independent audit at least once per year, and they have to pay for it, and they have to have a compliance officer within their structure. As to the meta obligations, they're mostly self-assessment obligations, not self-regulatory. And to quickly conclude, when I look at the obligations, I would say that mostly they are comprehensible. But are they so transparent in itself? Well, let's look at this. Those are major obligations that are sanctioned very severely. So they have to be transparent in itself, so the platforms know what we are expecting from them. And here are some of the questions I asked that need to be answered, and I hope will be answered in the coming months. So there is a need for a more transparent appeal system, so it's not so arbitrary. Need for transparent independent audits, and the rules for independent audits just went public consultation process. It ended just a few days ago, so I'm eagerly awaiting the result of the consultation process. How detailed those obligatory reports should be, because like I mentioned, the obligations in DSA are very general in the nature, and we have to keep that in mind. So another regulation is still needed, the delegated regulation, to put the details in place. And of course, the mapping of technical requirements. Online platforms are required to give a lot of data in different forms. So we have to bear in mind the balance between what is given to the user or any other entity that's requesting the information and balancing the trade secrets and privacy and all other interests. So right now, DSA is in the testing phase. Online platforms, the big online platforms, the very large online platforms, will have to comply with obligations starting from the end of August, and all the other online platforms in a year and a half, more or less. And what is very interesting, that we have designated very large online platforms, but it's up to those smaller online platforms. They have to conduct compliance audit if they are obliged to comply with DSA. And I will end with that. Thank you.
Well, dziękuję, Professor Knapp, for handling this challenging topic within the allotted time slot to you. The next speaker is Professor Popovic. Dusan, you have the task of speaking about Sisyphus.
Thank you. Did you switch off? Thank you. As you have seen, I was preoccupied this year with the freedom of expression. Why? Well, probably because I'm getting old, and this is a way of me saying that I care about people more than I did when I was young. So in the last few papers I've written, I have been curiously preoccupied with this topic of the freedom of expression, and this time I will consider this topic in the context of content moderation. I will keep my presentation without going into extreme details, because I'm aware that not all in the audience are lawyers. In my upcoming paper, I have analyzed basically two sources of EU law. One is the Copyright in the Digital Single Market Directive, and to more detail the Digital Services Act that both deal with content moderation, the CDSM directive dealing with something we could call the copyright content moderation, and the Digital Services Act dealing with the general content moderation. I have identified 3 risks for the freedom of expression. The first one being that content moderation may lead to general monitoring, although the European Union and these sources of EU law keep on repeating that general monitoring is prohibited. The second challenge would be a content moderation leading to information bubbles, which Magdalena already mentioned. And the third one is a content demotion or content suppression, meaning that the content is not always being removed, it is not always being deleted, but it is difficult to find it. It doesn't appear in recommendations or in the search options. And there is a question which is raised by a scholarship whether this leads to some kind of censorship. So the general monitoring issue and the CDSM directive. So as you know, this directive introduces a new notion, a new concept of the online content sharing service providers. That is a subcategory of hosting providers. So the concept departs from this concepts we are familiar with for the last 20 years since the adoption of the directive on electronic commerce. The online content sharing service providers have a difficult task, which is to make their best efforts to implement the solutions which need to ensure the unavailability of specific unauthorized content. So they need to remove the illegal content, and they also need to prevent future uploads. And if you need to prevent future upload, then immediately you would need to ask yourself whether this can be done without general monitoring. And another issue is what to do with the situations in which online platforms are removing content which represents legitimate use. So whether the algorithms which are currently being used by the online content sharing service providers are able to differentiate between legitimate and illegal content. So the European Commission basically told us no. At the current stage of development of technologies, we cannot say that there is a technology which can, in every possible situation, differentiate between legitimate and illegal content. So what the European Commission suggests us is to switch to a reasonable practical standard, and that is the standard of manifestly infringing content. And this standard should be applied in order to decide whether the content will be blocked or it should go online. If an upload matches a specific file which is provided by the right holders, then it is a manifestly infringing content and should be blocked. But if it is not manifestly infringing, then it should go online, and there should be ex post human review of that content. However, there is certain content which is, as the European Commission says, particularly time sensitive. For example, pre-released music, and in that situation, the European Commission suggests that there should be ex ante human review of such content. So from the perspective of those that need to comply with these rules, this is extremely costly to have ex ante human review of such content. Imagine the quantity of such content which is being uploaded on YouTube, let's say. So at the same time, the European Commission then says, well, this mechanism should not lead to a disproportionate burden on the service providers. So I would be rather cynical, as I tend to be, to say that the European Commission first imposes certain duties which are extremely costly, and then it says, well, it shouldn't be extremely costly. When I say that the European Commission suggested something, I actually am referring to the guidance the European Commission issued on Article 17 of this directive. And this guidance actually was adopted quite late. It was adopted only 3 days before the transposition deadline of the CDSM directive, so it was not of great help to the member states of the European Union that needed to transpose this directive into their national copyright rules. And furthermore, this guidance is just a communication by the European Commission, so it is not binding on the member states. So how did the member states deal with this issue? Some just copied the wording of the directive and are waiting basically for the Court of Justice of the European Union to decide on some complicated concepts introduced by the directive. The others tried to be more precise, which is how we normally perceive the Germans. So I will give the example from yes. So I will give the example of the German legislator that introduced the concept of uses which are presumably authorized by law, and these uses must not be blocked automatically. So actually the German legislator offered us some more or less quantitative thresholds. And these are cumulative criteria. For example, the use must consist of less than 50% of the original work. The use must combine parts of the work with other content. So there must be some kind of creative input. And the use must be minor. So it is minor when it is sort of non-commercial, or if it lasts, for example, less than 15 seconds. Or if it surpasses these quantitative thresholds, then the user must flag it as being covered by an exception. What problem I see in this approach is that copyright law is not so clear-cut, so there are uses which are covered by exceptions and limitations and which allow you to use, for example, the entire copyrighted work. So if we were to apply these quantitative thresholds, this would lead to some outcomes which would be contrary to copyright rules. And once again, such complex analysis cannot be performed by software. This is also true. In the meantime, there was an input from the Court of Justice of the European Union in case Poland versus European Parliament and Council, where basically the Court of Justice of the European Union told us that limitations to the freedom of expression are permitted, and that the content should not be blocked a priori in all instances, and that the technological solutions which are adopted in order to comply with the directive need to appropriately discriminate between lawful and unlawful uploads. There is one problem with this court decision, and that is that the court decision does not give us any indication on where to find such algorithms which can differentiate properly between legal and unlawful uploads. So switching quickly to the Digital Services Act, I would like to emphasize some of the rules contained in this act which are related to content moderation. So these rules apply to cases not involving copyright protected content. And this Digital Services Act leads us back to the concepts we are used to since the adoption of the EU directive on the electronic commerce in 2000, but also introduces some new concepts which were already mentioned by basically all the speakers before me, the very large online platforms and very large search engines. So there are asymmetric due diligence obligations which are applicable to different types of intermediaries, and the most of the information are applicable to very large online platforms and very large online search engines. So there must be an access to an effective internal complaint handling system. There are some duties related to the transparency. There are trusted flaggers which are given the most benefit credit to when notifying the content which is probably contrary to a law or the general terms. What the Digital Services Act also introduces is a Good Samaritan protection copied from the US law. However, it only introduces one half of this protection, so this a Good Samaritan rule actually is applicable to actions which are introduced by online platforms voluntarily, and in that sense they enjoy the immunity if they have taken the voluntary action to remove certain content, but they will keep that immunity only if they had dealt in good faith, meaning that they need to comply with the principle of non-discrimination. This is also problematic if we understand the way in which these platforms function. For example, if we train these algorithms on certain type of content, then clearly the algorithm will be biased and there can be decisions which are discriminatory in their outcome. So I will have probably just 1 minute for the remaining concerns. The second one being the content moderation leading to information bubbles. The Digital Services Act addresses the problem of recommender systems, of the algorithms which are recommending content to the users. These algorithms need to be more transparent now, so as a user we will be able to learn in which way the content is being recommended, and we will also be able to choose at least one option which is not based on profiling. The third concern I have identified is the content suppression. This is the situation in which the content is not being removed, but it is difficult to find it in the search option, or it is no longer being recommended. So the problem with content demotion is that we were not aware of the rules under which the content is being suppressed, is being demoted. Following the adoption of the Digital Services Act, we'll be aware of that to a certain extent, because the content demotion is recognized explicitly by the Digital Services Act as one of the techniques applied by the online platforms. However, the Digital Services Act is applicable to content which is unlawful or contrary to the platform's terms and conditions. The problem is that content demotion techniques are applied even to the content which is not contrary to the law or to the terms and conditions, but is, as they say, borderline, so close to being contrary but not being contrary. If it is not contrary, then the Digital Services Act duties will not apply to that, which is another concern to be resolved in the next years to come. So I will finish just by signaling what needs to be clarified in the upcoming months and years with regard to the CDSM directive. Clearly, this directive is packed with notions that need to be clarified by the Court of Justice of the European Union. For instance, what does the best effort mean? And the Digital Services Act, the main problem which I see is that although this is a regulation, and I will only thank God that this is not a directive, still what is unlawful is decided on by national law. So the definition of unlawful content is not an EU concept. Thank you.
Well, thank you very much. May I just express the gratitude to the first two speakers, and now I open up the floor for Q&A. There's a question down there, and just at the bottom there.
Hello there. I have two questions for Dr. Popovic. In terms of from what I understood, a quantitative threshold for protection of intellectual property. In terms of the German definition, it does not cover content that is shorter than 15 seconds. So my question there would be, what would be your comment in terms of platforms that use short content as their specific business model, how the two interact, so the quantitative threshold and the business model? And the second question in terms of DSA, from what I understand, there is a Good Samaritan standard that can be applied. Can a digital services provider invoke the Good Samaritan standard when specifically, let's say, a country deems certain content as prohibited, but whereas that content could or could not be prohibited in terms of the law? So could a digital services provider call upon the standard of Good Samaritan to say, we are going to allow this specific content? So that's that.
Thank you. Well, the German approach was quantitative in the sense that they were presuming that certain content is lawful if it is of below certain thresholds, and if it has a certain creative input added by the user using such third-party content. The problem I was signaling is that in certain cases we can still be covered by the copyright exception and limitation, even if we are using the entire work. For instance, in case of news reporting, or in case of quotation, if we would like to quote a copyrighted work, which is an extremely small quantity, so you cannot quote only one part of it. So in that sense, the German approach is not flexible enough, and is not in my view in line with the aims of this piece of legislation, because the aim was precisely to allow uses which are covered by exceptions and limitations. And as to your second question, indeed we did borrow this Good Samaritan rule from US, but only one half of it. So if an online platform conducts certain voluntarily actions according to certain standards like fairness, transparency, non-discrimination, etc., it will enjoy immunity. But the other half of the American rule is not applicable, because clearly in Europe we have prescribed certain due diligence duties to these online platforms, so they do need to behave in a certain manner in order to meet those standards.
The next question is from a gentleman in the first row here, and then there's somebody back there.
So again, I'll keep with my theme from this morning, which is about the usefulness of all this. And, you know, I mean, other than being interested in regulation, I'm also a private lawyer. So I'm thinking about these rules from the perspective of somebody who kind of like, you know, wants to participate in the market in some way. And, you know, what extra options it gives them. And as we know, I mean, this is for both speakers, you know, transparency is a mixed blessing because, like, you know, you can always be buried in information that you can't really use. So there is a case about an app developer from Australia that basically gets deleted from, you know, the Android App Store. They're a small developer. They're told that they're not actually complying with the terms and conditions of, you know, the App Store. So I'm thinking, okay, so how is all of this apparatus that you're discussing, you know, useful or not useful to this sort of small app developer? You know, they went to ask for a preliminary injunction, they got it, but, you know, the litigation essentially buried them, so they went into administration. You know, they might now have access to the terms and conditions, but, you know, do they kind of get any benefit from all of this if they, you know, are faced with this kind of action by Google?
Okay. So I will try to answer this question from the perspective of Digital Service Act. Well, in theory, they should have more mechanisms, but I would say just the beginning, because DSA also sets another mechanism out of court, dispute resolution. So this should speed up the process apart from a judiciary process. They should be able to communicate more with the platform. The platform should be more transparent why they refused to put the app, and they really have to justify it. They cannot be arbitrary in that sense. So maybe those kind of mechanisms might help. And also, if the platform fails to comply with those obligations, they face real consequences. So that might also force them to better justify their decisions. Well, if you're facing a fine amounting to 6% of your turnover, I would say that's a very strong argument for compliance.
If I may just add, well, I share Professor Svetia's concern, but I would say that the major benefit of the whole package, which started in 2019 with the adoption of the CDSM directive, would be this transparency. At least we are no longer kept in the dark. We know why certain decisions are adopted and how. Even the researchers had some basic problems before not being able to learn about the decision, about the contents of the decision, criteria, quantity. We will have all these transparent now and in yearly reports.
The next question was somewhere down there.
That was me, thank you. I would like all the participants basically to comment on the recent case concerning Amazon shutting down the entire smart home of an Amazon user. Are you aware of the case? The delivery man, here goes. The delivery man misheard the doorbell basically of an Amazon user, and he characterized it as racist, which it wasn't, but it's another pair of sleeves. So Amazon discontinued all the services related to SmartCom Amazon Echo services, so the man was kept in the dark in his home without any utilities provided by Amazon due to something that in the end should be regulated by public servants who have been voted for by the citizens. How would that case be regulated, and what would be the repercussions had it happened in Europe in light of the Digital Services Act? So Amazon having shut down all the services because the delivery man misheard a doorbell.
Okay, so I will try to answer this question this way. It's not a problem of this man, but also many other business users that rely completely on online platforms as the only way of disseminating information or offering their products. So that's why we also need this transparency to not rely only on the terms and conditions of the online platforms. They are not the law, they're just internal regulations. We still have the legal provisions, the national legislation, and we cannot forget about it. So yes, that's one of the reasons why we need DMA, DSA to provide that kind of transparency, to exclude that kind of situations when somebody is immediately cut off from its main source of income and the ways of conducting business. So DSA specifically provides mechanisms for that kind of situation, but they are not in place yet, still several months until they enter into force.
Just to
Any more questions?
Yeah.
No, it's not a question. I wanted to ask another thing. Do you think that this might lead to ultimately to unbundling of services and tie-ins that are inherent to the service rendering by those large service providers, the way it was back in the days for public utilities?
Sorry, could you repeat?
Do you think that this calls from increased transparency, which are now in place, would ultimately lead to the requests for mandatory unbundling? So that is to say, to require Amazon, for example, to separate its one type of services from its another type of services, the way the public utilities were once required to do?
That is a very interesting question. I'm not sure the DSA goes that far. It just provides some obligations for transparency, but not that kind of structural remedies. It relies mostly on self-assessment, so I would say if online platform decides that this is the best way to comply with the obligations, it can proceed this way, but there is nothing that forces it to do and undergo that kind of structural changes. The DSA is horizontal in its approach, so it doesn't differentiate between the platforms. So this platform is for streaming mostly, this is for music or other industry. It addresses them, all of them, at once. And each platform has to come up with the solutions tailored for this platform. When it comes to systemic risks, when it comes to transparency obligations and any other measures they have to implement.
Okay, ladies and gentlemen, thank you very much for your excellent questions. And now I close the Q&A session, and that brings me to my own presentation. I'm going to talk about digital platforms between unfair trading law and data protection. Perhaps as a starter, I might just use the last question which was asked prior to me taking the floor. That was the Amazon question. Under German unfair trading law, you would have a very good case suing Amazon for breach of fair trading standards if there is an immediate closing down of your account. And that in a way shows that we have to look at the legal structure, at the legal norms below the DMA, and we also have to look at the legal framework for those platforms which are not covered by the DMA simply because they're not big enough or because the Commission hasn't issued the certificate that a platform qualifies for a core gatekeeper. What I want to do today is I want to take a look at the platforms, as I said, below the DMA standards, and I want to analyze to what extent unfair trading law is capable of closing loopholes below the DMA threshold. In order to do this, I would like to take a brief look at the figuration of the platforms by suggesting an approach that is informed by the theory of the firm, and then I would take a closer look at what's going to happen with smaller platforms and to what extent unfair trading law is capable of addressing some of the concerns which have just been expressed by the Amazon example. And then I would like to briefly examine whether the GDPR somehow frustrates certain aims of unfair trading law, if unfair trading law were capable of telling platforms to open up for others who want to use what is stored by the platform. In taking a closer look at the platforms, let me briefly analyze the configuration of the platforms. Basically, we do know that basically they're transaction platforms and innovation platforms. But what is really interesting from the analysis of the governance structures of these platforms is hybrids and the question when platforms do mature. Now we do have, sorry, there's a completely breakdown of the colorful illustration, so to speak. Ladies and gentlemen, I go on even though you're deprived of taking it. There it is. Basically, the theory of the firm says that at a certain stage, certain activities which are organized by the market can be integrated into one firm. If you look at the basic underpinnings of the DMA, the DMA pretty much says that we do have a core gatekeeper which too much of the functions which you usually have on the market are integrated into the platform. And what the DMA does is it basically tells that platforms, core gatekeepers, need to divest by opening up services to those who can't access to the platform. And the DMA also says that to a certain extent you must allow access to the platform if third-party providers would like to get access to the data stored on the platform. So we do have two conflicting mechanisms which are envisaged by the DMA when it comes to analyzing the regulatory instruments for platforms. On the first hand, we do have a decided effort by the DMA of curtailing overly integrative governance structures, because the DMA certainly doesn't expect core gatekeepers to do everything. But then we also have, on the other hand, we have the decision of the rulemaker, of the European rulemaker, to force integration, so to speak, into some of the services of the DMA by allowing access to certain people who want to get access to these platforms. Now, these are two very idealistic perceptions of what the DMA does, because the interesting perspectives are those services which offer hybrid services. Do you consider somebody who has a long-term contract with a platform, do you still think this is somebody participating on the marketplace, or can you already say this is somebody who is already integrated into the platform? Now, when it comes to platforms qualifying under the DMA, this is quite simple. But what do you do with platforms which haven't yet reached the threshold of the DMA? Because there you have to decide, is this a market participant, or is this a company which is close to hybrid structures? The reason why I'm emphasizing this issue is the following. When it comes to the application of unfair trading law, at least for German standards, we have to analyze whether there is a competitive relationship between those who seek judicial redress and to those who are defendants. Now, if they are integrated too well under a long-term contract, you're going to have a problem with establishing a competitive relationship. And that later on raises the question whether you need to change unfair trading law in order to accommodate situations where somebody has a long-term contract, but basically is economically dependent from a platform that doesn't yet qualify for the DMA. And then finally, we also have fairness and transparency for consumers. And consumer protection, of course, is a legislative goal which transcends the DMA. And the question then is, can we also use consumer protection norms for getting hold of platforms which do not yet qualify for the DMA? Now, I don't have to talk about the DMA because basically the fundamental legislative thrust of the DMA has already been addressed. What is transparent under the DMA is that you have an imbalance of rights and obligations, and basically there is a mismatch, so to speak, between an undue supply of personal data and the products and services you get in exchange. What is behind this, if you transcend beyond the DMA, is the realization that you obviously do have to analyze certain welfare effects if you want to start laying down ground rules for people doing transactions or envisaging transactions with platforms below the DMA threshold. Now, when we look at norms below the DMA threshold, we do realize that we have a look at unfair contract terms, and we do realize that there is national competition law. From a German perspective, there is the GVB, the law against competition infringements, which basically says that German antitrust law can apply even though the defendant just avails itself of relative market power. And there is 19a GVB of the German competition law, which basically resembles some of the mechanisms of the DMA. If we move below the DMA threshold, there of course is the P2B regulation, but the P2B regulation in a way is still instructed by traditional contract law thinking and the judicial approach towards contracts, which basically is an ex post approach which analyzes whether the standards of contracting with less powerful parties haven't been infringed. P2B is a nice thing, and so is the DMA, but neither of the two analyzes the question what happens with hybrids and what happens with business transactions where on both sides of the transactions you have business, the so-called B2B structures, or structures in a just-in-time scenario or technical enablers, which nowadays are also organized as platforms. There is the platform jurisprudence from the Court of Justice of the European Union. Some of the platform cases, like the Airbnb and Uber case, basically decide which standards of EU are applicable, whether it is the Airbnb, which just does renting apartments to citizens, to consumers, or whether it is the Uber scenario where transport law became applicable. But that, in a way, I think doesn't solve the problem of those platforms which are below the DMA's threshold. Now, if you look at French law, there are cases which classify a breach of the GDPR as a case of concurrence déloyale. And that raises the question, perhaps unfair trading law is applicable in this scenario. You tell me when the 3 minutes are. Yes. Okay. Thank you very much. Now, under German unfair trading law, I did mention the Amazon case a moment ago. You do have a case under unfair trading law in Germany if you're shutting down an account with a platform. And you do have an unfair trading case if you breach information duties. And you may have an unfair trading case if you breach local laws on private accommodation. Now, obviously, this operates to improve standards for those who participate in the trade, but it also improves standards for those who are keen on protecting consumer interests. If you look at the regulatory patterns of the European Union, if you look at the fintech legislation, what they are doing there is they are setting up professional standards, but they don't tell you what the consumer can do, and they don't tell you what private law instruments you might have in order to police unfair behavior by platforms. There are outsourcing rules by the European Banking Authority, but the problem with these outsourcing rules is if you look at the chain of contracts, at a certain stage it will be quite unlikely that the standards which are mandated by the law will be handed down the chain simply for practical reasons. There is the directive on unfair commercial practices, which protects businesses and consumers, but again here we have a problem with hybrid structures and competitors for new businesses. This made me have a look at the data access provisions both of the DMA but also on the Payment Services Directive, on the amended Payment Services Directive, because there are requirements whereby access to data, thank you, has to be granted. And if we try to transfer this to unfair trading law, obviously we do know what we want to address. We want to ensure portability and interoperability, and we want to shut down on externalities of data lock-in. Now, unfair trading law is about the respect for fair competition standards, but we do have a problem here. The problem is that we do need, in order to apply unfair trading law, we do have what the law, at least German law, calls a competitive relationship. If you can't establish a competitive relationship, you do have a problem. There is a provision on the German Unfair Trading Act which says that, okay, if you obstruct competitors, then there is a case for suing somebody for breaching unfair trading law. But the problem is, if somebody wants to get access to data on a file to open up a business, you can't really say that these two are competitors. You might say they are potential competitors, but I think this is going to stretch judicial indulgence beyond its limits. So I think what we do need here is we do need some legislative intervention to stretch this notion of obstructing competitors even below the DMA threshold. Now, that brings me to data protection problems in pursuing this approach. If you say that a potential competitor would get access by, thank you very much, would get access to the files, you are also assuming that those who own these data, so to speak, those who are concerned about these data, they must give their consent. And the question there is, how far does this consent go? And this is even a problem under the DMA. If a gatekeeper were forced to disclose data, the gatekeeper might still say, oh, well, sorry, but I can't do so because I might be breaching the GDPR, the GDPR obligations. And this is something a legislator needs to solve by modifying existing unfair trading law. There is also a problem under the GDPR, basically because, I mean, if a gatekeeper has to share data, is he still a joint controller within the means of the GDPR, or what is his role? And this is not a theoretical question, because this can raise issues of damages under the GDPR. And again, I don't think that the law as it is on the statute book can solve these problems. So we do need intervention also in order to harmonize this potential interface between unfair trading law and the GDPR. Now, to conclude, to sum up, basically, if we open up unfair trading law in order to prevent obstruction of potential businesses, we are forcing some cooperative patterns on those who are the owners of platforms. But the problem, I think the real problem is, even if we are inspired by consumer instruction, we still have to do something on what unfair trading law so far calls the competitive relationship, and we have to make provision for this type of potential competitors who need to get access to data in order to be able to open up a new business. And in this country, they say, hvala. The next two speakers, or the next speaker, is Professor Papadopoulos from Cyprus, and there's also Dr. Kofina, who has contributed to the presentation of the two. You have the floor.
Thank you so much for the invitation to participate in this very interesting conference. The topic of our presentation is Digital Markets Act, a promise for a fairer digital environment. It is a joint publication with my colleague and PhD student. I will start the presentation, and then my colleague would continue. This presentation would start with a discussion on the datafied society, the importance of personal data, of course, the wonderful digital world, which is the central point in this analysis. Then our main focus will be on the Digital Markets Act, the collection of data in the context of the fair competition. We will continue the analysis of the Digital Markets Act. We will scrutinize data portability and the safeguard of privacy. Then we will continue with the issue of sharing of data and, again, the safeguard of privacy. The subtle balance and the conflicts and the proposed solutions to these conflicts between the Digital Markets Act and the GDPR, and some concluding remarks. First of all, our society is already well known. It's a datafied society. Data play a central role. The benefits of the digital world are innumerable, both at personal level and, of course, at societal level. And the benefits, the importance of benefits, of course, was revealed extensively during the recent pandemic. Of course, many aspects of our daily life is digitalized. For example, the remote education, the remote working, and of course, various other aspects, such as online partying. It's something very, very common nowadays. This is a tendency. Our digital activities now are leaving certain digital footprints. We have cookies and algorithms and various other digital and electronic mechanisms which are processing these digital footprints to the benefit of certain digital companies. The data is, of course, something very important for such digital companies, and nowadays, according to the economist, a very, very famous statement published in The Economist, the world's most valuable resource is no longer oil, but data. And especially in a data-fied society, is something very important. Now, in the context of the wonderful digital world, the basic doctrine is that whoever controls the data controls the market. Of course, this is we're talking about locked digital markets. Someone who controls the data is locking outside its competitors, which is very dangerous for competition. It could result in very serious anti-competitive practices, such as the potential abuse of market power. Nevertheless, this structure, this doctrine, is not available for all market players. There are some market participants which are not capable of controlling the data. This means that their position in the market is not so strong as other players who have such possibility. And the central issue between fair competition and data in the context of digital markets has to do with the existence of the big tech companies, the GAFAM, the well-known GAFAM, Google, Apple, Facebook, Amazon, Microsoft. Again, here, the welcome to the GAFA land, where the winner takes it all. All includes, of course, data and the control of competition. This is a central point and the central problematic issue here. Now, the Digital Markets Act, what is the impact of the Digital Market Act on the level of competition? First of all, will the enforcement of the Digital Markets Act ensure that competition won't be distorted via the control of data? This is the first central question in our research. The second one, does the Digital Markets Act provide the tools to ensure a level playing field for all digital companies, irrespective of their size and power? What about the smaller companies? How would the provisions of the Digital Markets Act be applied in conjunction with the GDPR so as to ensure the safeguard of personal data? Because the GDPR is a more specialized piece of legislation aiming at protecting personal data, obviously. And the question is how these two are balanced, because there are certain issues of conflict. The Digital Market Act introduces an ex-ante control, antitrust control, in comparison with the treaty articles, Articles 101 and 102, which are used for an ex-post antitrust intervention. The Digital Markets Act is introducing an ex-ante intervention. They are imposing certain do's and don'ts to gatekeepers. And the basic, of course, aim, the most important aim, is to prevent anti-competitive control. With regard to the collection of data and fair competition, the key point here is who is a gatekeeper? Because, all right, we have the do's and don'ts regarding gatekeepers about establishing a fair competition environment, but who is a gatekeeper? The definition is provided by Article 3. An undertaking shall be designated as a gatekeeper if it has significant impact, offers a core platform service, and of course it has an entrenched and durable position, a very strong position in the market. And this includes, of course, the big tech companies, browsers, search engines, virtual assistants, etc. And now I'm passing the floor to my colleague.
Thank you. So, starting a summary of those do's and don'ts of the gatekeepers and Article 5.2a of the Digital Markets Act, where we have the prohibition of the gatekeeper to combine personal data unless the individual has been presented with a specific choice and has been given his or her consent. Hence, we have our consent to be considered as a tool so as to address any competitive harm that might be caused due to the combination of personal data. However, is the consent an adequate mechanism for keeping digital markets contestable? This is questionable, since it will depend on individual users' choices. If we take, for example, Meta, Facebook, and the majority of the users of Facebook agree to have their personal data combined with their personal data that were already shared with WhatsApp and Instagram, how fair competition will be safeguarded under such circumstances? Additionally, in the digital environment, we have situations of take it or leave it. Unless we agree and provide our consent, we shall not be provided with a specific service or a product. Additionally, we come across too complex, long, and difficult to understand terms and conditions and privacy policies. No one can easily understand what is happening with our personal data, who has access to our personal data. Moreover, gatekeepers can easily trick us into agreeing to the combination of our personal data without us realizing actually what are the consequences of such combination. Hence, the risk of gatekeepers to continue exploiting their competitive advantage still exists, not only to the detriment of small companies and potential new competition and innovation, but also to the detriment of us as consumers. Moving forward to the requirement of data portability, the Article 6.9 of the Digital Markets Act. Each gatekeeper is required to provide the individuals, us as end users, at our request and free of charge, with effective portability of our data, and also to provide the tools to facilitate the effective exercise of such data portability. The right to data portability was first introduced in Article 20 of the GDPR. Each one of us, as data subject, is entitled to receive the personal data that he or she has provided to an entity, the data controller, where such use is based on either consent or a contract. However, the exercise of the right on data portability is limited in cases where this is technically feasible. Hence, isn't data portability the two sides under the GDPR and DMA, two sides of the same coin? It seems that the Digital Markets Act provides a broader scope of the right. More specifically, under the GDPR, it is specified that the right concerns only personal data, while in the Digital Markets Act, there is no such restriction. So it also, someone can easily argue that it covers non-personal data as well. As already stated previously, the GDPR right on data portability is restricted in cases where the exercise of the right is technically feasible. However, under the Digital Markets Act, gatekeepers are required to provide the tools to facilitate the exercise of such data portability. Hence, a larger burden is set on the gatekeepers. Lastly, in the GDPR, we have the personal data that are being processed on the basis of a contract or consent, while in the requirements of the Digital Markets Act and the portability exercise, it seems that it also covers personal data that will be processed on either of the 6 legal bases of the GDPR, either legal obligation or legitimate interest basis. Moving forward to Article 610 of the Digital Markets Act, and this is the requirement to provide access to data to business users. More specifically, when the sharing of data concerns personal data, it is indicated that such sharing can take place only where the individual concerned has been provided with a choice to give his or her consent. The purpose of this article is to weaken the gatekeepers' exclusive access to large sets of data and to encourage data sharing actually between competitors. However, it is very challenging to remain GDPR compliant. For example, how can compliance with the purpose limitation principle be ensured, while in the case where the business user that will use the personal data might use them for a different scope and purpose than the purpose for which the gatekeeper originally collected the personal data in place. Additionally, how can the gatekeeper ensure the collection of a valid consent from each individual within huge data sets? For example, if we take the example of Facebook or Google, and how can each one of us as users of those platforms can provide a free and specific consent for sharing our personal data with other business users? Hence, we have obviously overlapping and conflicting obligations arising under the Digital Markets Act and the GDPR. Of course, we have two regulations, two European regulations with different scopes and purposes. While the Digital Markets Act intends to create fairer digital markets with unhindered access to small and startup companies, the purpose of the GDPR is to safeguard our privacy. Additionally, while the DMA wants to allow data sharing between competitors and open the market, the locked-in digital markets, the GDPR intends to restrict the unjustified sharing of personal data.
You have to conclude.
I'm already in the concluding, thank you. In conclusion, without any doubt, the European Union is a pioneer in enacting a regulatory system so as to regulate big tech companies. However, can big tech companies comply both with their obligations under the Digital Markets Act and the GDPR? How the identified, overlapping and conflicting obligations can be balanced, coordinated, and conciliated? Is this actually a promise for a fairer environment, not only for business entities and the creation of a fair competition, but also for us as consumers, and also for us and our privacy? Thank you very much.
Well, thank you very much to my co-speakers. I have been instructed to allow just one question because we are running late, and I would be ready. Yes.
So just a short question. From what I understood, in conclusion, GDPR versus DMA and DSA is a very complicated issue, but this is a question for the whole panel. From a practical standpoint, could you comment on legitimate interest versus consent as regulated by the DSA and DMA in terms of the fact that the businesses do have a legitimate interest in conglomerating all the information from all available sources versus their obligation not to create basically an information trust. So,
who wants to take the floor? Can I just say, at least because I was talking about the unfair trading perspective, I do not think what you qualify as an interest of a business is necessarily the interest envisaged by unfair trading law. This is a matter which basically legislators have to decide. So I do not think that a generalizing answer to your question is possible. Building a conglomerate is a legitimate interest for a business, but this doesn't necessarily imply that it is a legitimate interest which the legislator or the courts would classify as legitimate.
if I could specify, not in terms of the business itself vis-a-vis the antitrust regulation, but the legitimate interest in terms of creating a legal basis for processing of users' data. So they have a legitimate interest to collect the data and a legitimate interest to process every available data from every source they have, but also at the same time maintain compliance with the antitrust regulation. Correct?
In the interest of not assuming the chair, I would pass on this question to the members of the panel.
Well, I will try to address it partly. I don't think it's a problem of accumulating data. Just accumulating data is not an infringement. It's about how you use it. Similarly to antitrust regulation, just having a dominant position doesn't imply you're abusing it. So I wouldn't say just accumulating is a really detrimental thing. And well, if you are collecting that much data, well, this is what the DMA and DSA is about. Share it with others, let others use it. But then you have all those conflicting interests that have to be balanced.
I think this is a perfect topic to discuss over coffee. So thank you very much, and let's take a break.
We are about to start. Ladies and gentlemen, dear colleagues, the third session is about to start, and in this session we will hear the presentations by Dr. Tatjana Jovanić, professor at the University of Belgrade, Dr. Yanis Svetijev, professor at the University of Sydney, and Dr. Wei Lulu, professor at the Beihang University, who is unfortunately ill and could not join us, but we will hear the video recordings of her speech. We'll start with my dear colleague from the University of Belgrade Faculty of Law, Dr. Tatjana Jovanić, who will be speaking about the platform regulation, ex post and ex ante tools in the regulatory toolkit. The floor is yours.
Thank you, Dusan. First of all, thank you for this excellent opportunity. It's a pleasure and honor to be here. This is really a broad topic, the interplay between public ex ante tools and ex post tools. And when I see, for instance, there is a whole course dealing with competition policy versus ex ante regulation in regulated digital platforms, 5-week course. When I see this versus, I'm really intimidated because it reminds me on the neoliberal mantra, competition whenever possible, regulation only when necessary. And I'm really at odds with this mantra because I'm a regulatory governance scholar. So modern digital platforms are becoming public utilities, and we are living in a risk society. So they pose significant risks. So if we look from the perspective of risk-based regulatory strategy, there is no more strict distinction between ex ante and ex post tools. So the main point of my paper and presentation in the same time would be definitely the importance of compliance function, which is mandatory for big digital platforms. So definitely the first issue in regulatory governance of digital markets is whether there are rationales for regulation. And in previous presentations, we definitely witnessed that there are so many risks of consumer and competition law infringements on digital platforms, and the very nature of those large platforms contribute to their market power, which is per se the risk of anti-competitive conduct. Another specific rationale that is revealed by behavioral economics is that these platforms are prone to exploit behavioral biases of consumers. And of course, ex post enforcement of existing laws can be too slow, and of course, such harmful conduct may continue despite regulatory action. So although the interests of consumers and society are often listed among the key prerogatives or mandates of competition authorities, such goals are often interpreted in a narrower sense of competition, of economic regulation, but the risks that the digital world poses are far beyond those risks. There are broader policy goals, so the purpose of ex ante rules is mainly to ensure fairness, contestability, transparency, and innovation. So, like it is in the case of crypto markets, artificial intelligence, Digital services, definitely. The approach of the regulator is based on risk, and the legal framework in digital markets is therefore a mix of some new rules or existing principles and horizontal legislation. As I said, we live in a risk society, and risk has become a public good that requires state intervention. And from the standpoint of the regulator faces a dilemma of how to manage and allocate its scarce resources, and how to ensure not only rule-making, that rules are in line with business practices, that they don't curb the innovations, but on the other side, the regulators and supervisors are facing some issues in compliance monitoring, supervision, and enforcement. And that is why, if you look at the Digital Markets Act, 1/3 of its provisions is definitely risk identification, risk evaluation, collection of tools, impact assessments, etc. So it reminds us on, for instance, banking and financial services regulation, because it's really risk-focused, and it even introduces so-called systemic risks. The Digital Services Act is definitely a piece of risk-based and principle-based regulation. What does it mean? As I said, in the EU, the first area that was really, recognized systemically important institutions is banking and financial services legislation. And the fundamental assumption of this act, which is really asymmetric by design and discriminates between regulated actors, is that the bigger an online platform is, the greater is its impact, and the higher are the risks it poses to individuals and society. So the subject matter of the Digital Services Act is definitely mirroring the main approach to risk regulation in terms that risks are not materialized, but really risks are some unknown and probable events. So when it comes to the Digital Services Act, digital market is a specific market that contains some vertical rules, and these are introduced ex ante rules. But in essence, there are horizontal regulatory regimes that are applicable as well. And if we open the question, who are the regulators? This is definitely a complex regulatory regime and shared regulatory space. What does it mean? In countries where competition authorities are in the same time charged with the mission to protect the economic interest of consumers, there, like for instance in Australia, there maybe competition authorities are really the promoters of the regulation. But on the other side, if we look, for instance, in some other for some other examples, you see that, for instance, in UK there is Digital Regulation Cooperation Forum, and I found that even banking and securities regulators are part of this forum. Article 40 of DSA introduced the board composed of member states' digital services coordinators, but the recent decision on setting up a high-level group for the digital markets definitely shows that there are a number of sectoral regulators. So you see from this, what is the focus of horizontal regulation? So electronic communications, data protection, competition, consumer protection, and audiovisual media regulators. But this high-level group is chaired by the Commission's Directors General of the Directorate General for Communications, Network, Content and Technology, and the Directorate General for Competition, which definitely implies that there is no senior age between competition and regulation, at least from this wording. So, as I have said, DSA applies the concept of systemic risks, and we have heard in previous presentations that these risks may relate to dissemination of illegal content, negative effects on certain fundamental rights, etc. But in comparison with financial regulation, these systemic risks are not enough defined, because in banking regulation, you know prudential rules, you know the concept of market risk, etc. Here, it's even more vague. What does it mean? It means that the burden is placed basically on large platforms because they really need to develop effective measures to mitigate against systemic risks. So definitely, DSA is a piece of risk-based regulation. What does it mean? If you read, as I have said, between 1/3 and 1/4 of its provisions are definitely risk regulation mechanisms concerning risk identification, risk management, risk mitigation, information and transparency, external, internal supervision, audit, etc. One example are trusted flaggers, which should support more effective monitoring and reduce reaction time once harmful content is on the platform. But DSA does not only regulate very large platforms as sources of risks, but as well uses them in the context of risk dissemination. So up to this moment, we could realize that this is a risk-based approach, that it's outcome-oriented, and in the same time is process-oriented, and at least in the regulatory theory, we call this approach risk-based approach we call it meta-regulatory strategy. So there are a number of risks of risk-based regulation, and we know it, for instance, from the financial market supervision, where Basel Capital Accord enabled banks to develop their own systems of internal risk rating approach, and that basically was the main cause of the 2008 crisis. So there is a number of risks of risk-based regulation, and I will deal with them in the paper that I'm writing for the book. But on the other side, the over-enforcement of content moderation could, for instance, suppress legitimate speech and other human rights. So considering the fact that risks are great and the risk in technological innovations is a dynamic concept, the main idea is that risk-based regulation should remain flexible. There are some general principles of ex post and ex ante interventions. Very briefly, ex post competition rules are often interpreted as backward-looking, focused on a relatively narrow view of product markets that are driven primarily by demand side, focused on strategic behaviors, very fact-specific, and remedies are set to be neutral in terms of the broader implications for the industry. Whereas sector-specific ex-ante rules are taken to be forward-looking, based on broader public policy priorities. They often define markets in broader terms, not much on the basis of forces of supply, but as well of demand. They are not fact-specific. They are prescriptive or proscriptive, very specific in their prescription of remedies, backed by detailed remedies, constructed with broader notions of consumer welfare, and mostly important is that they are best enforced through independent sector-specific regulators. If we take a look at the typical structure of the regulatory toolkit in regulated network industries, we will see that some of the tools that are already mentioned in the presentations today really can be put in some of these three main categories of rules: price and profit rules, access and service rules, or industry structure rules. However, there are more rules nowadays, and for instance, ex-ante rules strengthening consumer protection, as previous presentations already indicated, DSA is introducing some more unfair trading practices and unfair contract terms regulation, introduces some specific consumer measures such as those related to scams, fake reviews, introduces dispute resolution standards. From the standpoint, for instance, of anti-money laundering, this is as well important: know your business customer, DSA rules, a number of transparency reporting issues, etc. And there are additional competition measures for digital platforms. And I think that Jana will really explain what is the specific approach of Australian Consumer and Competition Commission, because they have some principles when developing these ex-ante pro-competitive mechanisms. This is the taxonomy that I found in Australian Commission's impact assessment paper, and I think that they are really, really very brief, and I found this taxonomy be very interesting, so I will not go into this. Some of those tools were already discussed today, but I will get back, and I have 5 more minutes, and 4 to this. The whole Section 5 of the Digital Services Act and as well Digital Markets Act are really obligations that could be explained from the standpoint of the regulatory strategy of meta-regulation. If you take a look at this pyramid, it's in theory, but in practice it's the reverse. Meta-regulation is basically when someone orders that you as a company should develop your internal mechanisms, that you must abide by the goals of regulation, that you must define your own processes, and if you don't do so, you will be punished. So you are forced to self-regulate. So in Chapter 5 of the DSA, I see that risk assessment, mitigation of risks, provisions on risk response mechanism, independent audit, additional online advertising transparency compliance function, and transparency reporting obligations are definitely tools of meta-regulation. As well, there are tools of self and co-regulation where society may be engaged, such as voluntary standards, codes of conduct for online advertising. But I would just like to draw your attention to the definition of compliance function. Maybe I'm too personal because I'm a faculty sponsor of our new diploma or specialized course on compliance that we introduced from this year at the University of Belgrade Faculty of Law. And when I read this provision in detail, the provision of Article 28 of DMA and 41 of DSA, I was really amazed, and I found that this is the most detailed regulation of the compliance function in all industries, far beyond banks. Because if you read, for instance, the competencies of compliance officers according to DSA, you will see that, just by way of an example, cooperating with the digital services coordinator of establishment and the commission, ensuring that all risks referred to in Article 34 are identified and properly reported, that they are reasonable, proportionate, and effective risk mitigation measures taken. Organizing and supervising the activities of the provider of the very large online platform or the very large online search engine, informing and advising the management and employees of the provider, and then monitoring the compliance of the provider of the very large platform, very applicable, monitoring the compliance in terms of other duties. So practically everything that relates to risk is put in the compliance function, and that is why you have such firm regulation of independence of compliance officers. And moreover, it's my opinion that compliance officer is the right hand of European Commission in the regulated subject, because if you see here in Article 4, in paragraph 4, so yes, providers of very large online platforms shall communicate to the name and contact details of the head of the compliance function to the digital services coordinator and to the commission. It means that commission may contact the compliance officer before it contacts anyone else in the company. So I will just conclude with the fact that it will be necessary to develop compliance management systems, and that part of rules, internal rules, will have to be written in so-called compliance programs that contain rules on prevention, disclosure, investigation, and remediation. 15 minutes.
Thank you. Our next speaker is Dr. Yanis Vetia, professor at the University of Sydney. I would add a long-time friend of the University of Belgrade Faculty of Law. We had the pleasure of cooperating with Dr. Svetiev, even in the pre-COVID period, which was a long time ago, within one Jean Monnet project. So the floor is yours.
Thank you very much, Dusan. Not only am I a long-term friend, but I'm a kind of, a very frequent and enthusiastic visitor. And so it's always a great occasion to be back in Belgrade. Also because I'm actually from near here, if you might have gathered. So I have been assigned the task of talking about the topic of repositioning platform regulation in two specific jurisdictions, the United States, which is where I did my PhD, and Australia, which is where I originally studied and I'm now teaching. But in terms of my presentation, I actually want to begin by some framing comments about what exactly is a platform. I mean, there's a sort of assumption among all of the speakers that we know what we're talking about when we talk about platforms. I want to talk a little bit about what different kinds of platforms are and what distinguishes digital platforms in a way that might also be useful for some of the other contributors to the volume, since, as you know, we're all contributing to an edited volume by our two distinguished co-editors. Then I would like to talk a little bit about some of the difficulties of regulating platforms through different types of tools, which were nicely set out by all of the other speakers. And then I will turn to the two specific jurisdictions and some recent initiatives in the United States and Australia to regulate digital platforms. And my summation of both the US and the Australian initiatives, but also some of the others, is going to be a little bit pessimistic. So I think that there is a few problems which I can kind of, foreshadow. One is that I think that there is a lot of herd behavior among regulators and legislators who are basically proceeding on the assumption that we need new tools, and they're adopting new tools by borrowing either each other's tools that somebody else is doing, which haven't really been tested very much, or borrowing tools from elsewhere, as Professor Jovanic so nicely set out, from basically financial regulation, even though we actually have evidence that they didn't work in that context. And so I see this as a problem, this kind of herd behavior of adopting new rules which either haven't been tested or where there is evidence that they haven't worked very well. I work in the tradition of experimentalist governance or experimentalist regulation, where scholars who work in this field say, look, when you are facing uncertainty about the best way in which to pursue certain defined goals, and where you face limitations in actually enforcing your rules and implementing effective remedies, what you should really be preferring to do is to allow different units, different jurisdictions to pursue differentiated solutions, to subject those to monitoring and peer review, so that you both review the design of certain either rules or remedies, their effects in the market over time. You learn from that, and then you adjust the specific remedies or interventions, either because you realize that they were unnecessary, so you can remove them, or because you realize they're insufficient, so you need to kind of, increase their potency. And so that kind of basically gives you the background for both my comments and also my ultimate pessimism about all of this endeavor. So the first step is to reflect on what we mean by platforms and platform models of production, what's distinctive about them. And I think that, to understand what's a platform, it might be useful to think about, models of production that are not platforms. So one alternative to a platform is basically a fully decentralized model of production where there is minimal or no coordination between traders. This is the kind of industry structure that, might say Adam Smith had in mind, writing in the 18th century, and that's probably what's envisaged implicitly in economic models of perfect competition. I understand not everybody here is a lawyer. And this production model of fully decentralized production is what we might, associate with the first wave of antitrust, which favored essentially traders' freedom to decide and freedom from restraint on others. Now, as Dr. Kulm's presentation very nicely outlined, as the economy becomes more complex, coordination between traders becomes necessary. Otherwise, products will just not work together for their final users. And so to give you a simple example that has nothing to do with digital platforms, if there is one producer producing tables and another producing dining chairs, the chairs would not be useful for sitting at the table unless they can fit there under the table. So there is a need to coordinate the height of the table and the chair so that they would be useful to the consumer when eating. And so one solution to this problem, it's an old solution, is industry standards, where basically producers come together and they decide on the technical standards for production. This ensures interoperability between the table and the chair, but it might also incorporate quality standards or consumer protection standards if you think about it, because they might, the technical standards might specify certain rules to ensure that these are actually useful to the consumers. Now, another solution to this problem is to bring production within the same enterprise, as Professor Coombs pointed out. The corporate form, for example, was used very efficiently to integrate production of different, different steps in the production process into a hierarchical form of organization, namely the corporation. The Fordist model of mass production is paradigmatic of this. Everything is brought within one entity. And these is the basis of economic explanations of economies of scale to deliver efficiencies to market. And so by contrast to Adam Smith's metaphor of the invisible hand, the economic historian Alfred Chandler wrote about the visible hand of the hierarchical, vertically integrated corporation that delivered efficiencies to market. And we can associate this with the second wave of antitrust, the Chicago Revolution, that says, bigness is not a problem. It essentially delivers efficiencies of market to consumers. Now, from about the 1980s onwards, what we observe in production techniques is what used to be called the vertical disintegration of the firm. And so, these large corporations started to abandon non-core activities and to outsource the various aspects of production to other users, to other producers, sorry. Typically, the explanation for this is based on cost savings. So in large organizations, it's very difficult to monitor all of the employees and even all the managers, so they become, in a way, inefficient due to size. And also, there was a question of liberalization of trade in that period, allowing you to access lower-cost producers elsewhere, as well as lower transport costs. Now, an underappreciated aspect of why we had the big corporation decentralize is the use of information and communication technologies, because that is actually what enables you to communicate instantly and ceaselessly, in a way, with your other collaborators. And so firms started to look for ways to cooperate across firm boundaries. Sometimes this is called networked production, but this is a sort of slightly problematic term because the network is not fully decentralized. You need to have a platform that brings these different specialties and different users together, that develops a kind of common language for collaboration. And so, in the industrial organizations literature, you will find that producers like Boeing or Airbus are themselves described as platforms because they have to cooperate with many different producers of component parts in order to be able to then bring them together in an interoperable way to deliver a product to market, which is, a complex aircraft. In the current discussion on platform regulation, there's not much focus on these other kinds of platforms, but more on, let's say, the digital platforms. And we might ask, why is that the case? And so one explanation is that, maybe in these other sectors, what we call interbrand competition, interbrand competition is very strong. So even fashion producers like Zara or H&M are platforms that bring together many different independent producers to deliver certain products to different users. But maybe there is enough brand competition that checks their power. Maybe even for platforms with limited competition, like Boeing and Airbus, their component part manufacturers have other customers, so they're not so dependent on the one single platform. Also, platforms like Boeing and Airbus, they produce a product of their own, so they have good incentives to be good stewards of the platform, because otherwise they might lose capable suppliers. because these platforms, they really learn from their collaborators. It's very hard for a large organization to remain at the leading edge of technology for all of its component parts. So, you know, they actually learn from the collaborators, and they want to have many capable collaborators, so they're themselves not dependent on one particular collaborator. And so then what's distinct about the digital platforms that kind of like, you know, has produced this mass of regulation that, you know, the speakers in the previous sessions couldn't even get through in, you know, making their presentations. So, you know, they do provide this common framework language that brings different sides of the market together. They ensure communication and interoperability. They also involve very intimate collaboration through data exchange between suppliers, but also now with users who themselves become suppliers in a way, producers of content, as other speakers have pointed out. And it becomes, as Dr. Kulms very nicely explained, very difficult to distinguish different stages in the supply chain. Production does not rely on physical assets, but on code and the processing of data. They're the same techniques of production at all stages of the supply chain. So it sort of becomes very difficult to say what's one activity and what's another. And it becomes much easier to integrate products into the platform because you don't need any distinct production capabilities. And indirect you know, network effects deliver benefit to consumers when you integrate multiple functionalities into the data, into the platform. The final thing, which again, a number of the speakers pointed to, is that it becomes very easy to copy what your downstream collaborators do. And that's exactly what Microsoft did in the 1990s. It was an early form of self-preferencing of its own browser over another browser. And increasingly, these platforms are actually not producing any distinct product of their own. They only intermediate and then incorporate functionalities into the platform. And so we might want to even think about how old forms of regulation might have contributed to the patterns of conduct that we're observing today. So in the Microsoft litigation in the US and the EU, they said, oh, well, if you just copy what your collaborators are doing and integrate it into the platform, that's a violation. So now what do all of the platforms do? They buy nascent competitors rather than copying their functionalities. Now, if we're thinking about regulating platforms, one of the problems that I have with all of this kind of rule production is that there is not much thinking about, well, what existing, you know, frameworks are there for regulating them, and why are they not working, or why haven't they worked in other settings before we co-opt them into platform regulation. So, of course, one option that you have is to say, well, you know, we don't worry much about Boeing and Airbus. We trust them to be good stewards of the platform. Why is it that we think that the digital platforms will not be good stewards of the platform? Is anybody disciplining them? Why are their customers not disciplining them? Why are their collaborators not disciplining them? Why are not other ecosystems disciplining them? And is that discipline effective? Now, the second type of regulation is private law. So collaborators or private users can use contractual mechanisms to protect themselves from any kind of harm from the platform. If they cannot, we need to ask why not, okay? Otherwise, there's also regulatory private law, like consumer law or unfair competition law, that's already existing there. I mean, many of these provisions seem to mimic provisions that we see in consumer law, in unfair competition law. If they're not working there for some reason, why do we think that importing them now in this setting, they're going to work? Now, competition law seems to be treated as a default, given that the problem has been framed as a problem of platform monopolies and entrenchment of power, but it's not entirely clear that the tools of competition law work here as well, and others have talked on this. And then, as Professor Jovanic pointed out, there seems to be some kind of, you know, infrastructure intermediation that's going on here. And so tools from telecommunications in particular are being borrowed as an ex ante access form of regulation. But actually, this is very, very hard to do. Even in the telecommunications sector, it was very, very difficult to basically identify efficient forms of exchange between collaborators, and there was a lot of uncertainty about how to do that. So, with that by way of background, I'll give some comments about the two jurisdictions that I have been assigned. One is the United States. Now, you will see that the US discussion, you might be aware of it, has largely been influenced by these kind of what are called neo-Brandeisian scholars. Now, what does this mean? They're basically reviving the progressive era concern about the curse of bigness. Louis Brandeis was a US Supreme Court judge. He wrote about the curse of bigness and favored broad deconcentration of economic power through antitrust. The problem, of course, is that this is not really an antitrust law project because you cannot translate it into rules about what's legal and what's illegal, and then remedies about how you, in fact, enforce those rules. It's also a non-project, at least as an antitrust law project, because structural separation is impossible in a world based on ICT technologies. If you have distinct production assets, if you have distinct territories, like in the AT&T case in the United States, you can structurally separate. But here, what is it that you are basically structurally separating if you try to deconcentrate a platform like Google? It also will not be able to be done by the courts because the US antitrust doctrine is not supportive. If you cannot demonstrate effects, it's actually very difficult to win a case in the United States, and to demonstrate effects in a fast-moving technology sector becomes very, very difficult. The doctrinal framework for antitrust intervention in the United States is essentially based on the Microsoft decision, which involves balancing exclusionary effects and pro-competitive justifications. In that case, the regulator was very, very fortunate that the primary judge's decision was very, very one-sided against Microsoft. But then if you look at the remedial implementation, which most lawyers like us don't look at, you will see that both in the US and the EU there were significant difficulties with implementing the remedies in this legislation. Once you extend to a multi-sided platforms, like in the Amex case, and you're balancing effects across different users, basically the whole thing becomes very, very difficult to prove. Now, there are some more targeted interventions by the US regulators, including some recent ones against Microsoft and Amazon, and we can basically discuss those in the Q&A if we want to. And so, my point here is that the neo-Brandeisian project is basically dead in the water unless you create a massive new bureaucracy, which in the United States is untenable, and in any event, Brandeis wrote about the problems of big government as much as the problems of big corporations. In Australia, you will see few competition cases, because in Australia it's even more difficult to win competition cases because effects through judicial balancing are combined with a highly textualist approach to interpreting the statute, which, in the United States and in Europe you don't have that much, this kind of textualist approach of the words. Also, the Australian regulator has sometimes been ignored by big platforms because the market is regarded as too small for them to care. And so for what the ACCC has been doing is to try to find some new modalities. Some are more promising, like the News Media Bargaining Code, which identifies a specific problem where dissemination of news by the big platforms ends up giving too little compensation to the producers of news, to news outlets as producers of news, and then basically tries to say, okay, we'll encourage you to bargain for better terms, subject to a penalty default of an arbitrated outcome if you don't come up with your better solutions. Now that seems to have worked. The other part, which is the kind of essentially the this kind of mandatory codes of conduct with targeted obligations seems to just mimic the DMA to a large extent. So that's, you can see that, my final conclusion is that, I'm not optimistic because much of the effort is focused on norm production. It's creating a regime that's extremely complex, that some of our researchers need to use linguistic, machine tools to be able to understand what's in the law. And there's very little attention to enforcement and remedies. And so I'll stop there.
Thank you. We now have time for a few questions for the first two speakers. Yes, please.
Now there is this marketplace investigation against Facebook that the EU is doing, and it's a sort of self-preferencing investigation. They're saying you're self-preferencing your marketplace vis-a-vis other forms of peer exchange that can exist on Facebook. And Facebook says, well, we're not integrating anywhere. It's just something that happens bottom-up. Consumers starting doing this exchange, we're regulating it. And so, I wonder, so, there seems to be, the controversy is at the level of your first point, what is a platform and how do we define it, seems to be where a lot of the litigation also may be. And the second point is, does your skepticism extend to the DMA, or, do you see some more promise there? Thank you.
Well, so if the idea of the DMA is that it operates as a kind of, providing a set of form-based rules that are easy to implement, which is what form-based rules are supposed to be, right? You kind of you look at the rule and based on what you're doing, whether you're violating or not. I don't think that it delivers that promise exactly because of your example. What is self-preferencing? When am I self-preferencing and when am I not? If it's subject to a considerable amount of, controversy that requires years of litigation to resolve, we're back where we started from. So, the Google shopping case, which by the time it's concluded, it sort of doesn't matter anymore, mostly, at least for those who were involved in that, in that conduct. And so, on the other hand, it might operate as a penalty default, which encourages the platform to be a good steward or to collaborate with its kind of, other independent operators. That might be a bit more promising, but I'm not sure whether it will operate in that way.
Any more questions? Well, you will still have opportunity to ask a question after we hear the third presentation by Professor Wei Lulu, professor at the Beihang University. She will give a presentation on the following topic: from intermediary to gatekeeper, the new development of platform regulation in China. The presentation will last 7 minutes.
Dear colleagues, it's a great pleasure to be here to present my research. The topic is from intermediary to gatekeepers, the new development of a platform regulation in China. Basically, I will discuss 3 things. The first one is intermediary as a very limited gatekeeper in China. And secondly, I will talk about the new development of a platform as gatekeepers in China. And finally, I will reflect on the gatekeeper regime in China. It's an old story about the intermediary law. We all know China transplanted intermediary law from the West, but the Chinese approach is much more similar to the European approach. And in our civil code, we have a very comprehensive regime of intermediary liability and liability immunity based on the safe harbor rule, which means intermediaries only take notice and take down responsibility if they are technically neutral for the generating of user-generated content, which is very like the European approach. But in our administrative law, the legislators actually asked more from intermediaries. For example, they will say, well, the ISPs should be responsible for the legality of the content generated by their users. This raises a very difficult question about how to reconcile this administrative duty of care with the civil liability immunity, because as we all know, if the intermediary take involved more in the generating of the content, they will have less chances to claim liability immunity in civil suits. And this trend continues in the platform regulation. For example, in the Chinese e-commerce law, the e-commerce platforms are asked to be responsible for the life and health of the consumer. If they failed to do this, they may be claimed to take liability with the infringer. And also in the Chinese data protection law, the very large or complicated platform service providers are required to be responsible to supervise the compliance of personal information protection obligation of the producer or service providers within their platform. This responsibility is gatekeeper responsibility, which is different from the data controller's responsibility for the data processor in the EU approach. Recently, we may have a comprehensive approach of gatekeeper in China, but it's a proposal in 2021, which our State Administration for Market Regulation published two guidelines. One is about the classification and gradation of internet platforms. And the second one is a very comprehensive list of obligation compliance for the super platforms. I will not go through the detail because of the time limit. So how much time left? And finally, about the reflection, we can see that both intermediaries and platforms are deployed in China as gatekeepers. So the Chinese gatekeeper regime is a hybrid system and is developing now from a sectoral regime to a comprehensive gatekeeper system, but still lacks theoretical foundation. For example, Chinese scholars will discuss, do they follow the same logic in the intermediary gatekeepers and the platform gatekeepers? Some scholars say, yes, they follow the same, but some scholars say, no, they are totally different things. But for me, I think there are at least two types of gatekeeper when we talk about asymmetry. Because there's a structure asymmetry-based gatekeeper and a power asymmetry-based gatekeeper. we can identify in the Chinese legal system. And the shortcomings of the gatekeeper system in China is we do not have a very neatly defined concept for very important actors such as intermediary and the platform, or we only have very broad definition. The result is it will very easily lead to the expansion of gatekeeper obligation, which is too comprehensive and too burdensome for the market players. So finally, I will say, when we think about imposing gatekeeper obligation to platforms, we should base on structural asymmetry or power asymmetry between platforms and other market players. More details will be present in my paper, and we may discuss deeper. Thank you.
Thank you. We have heard the last presentation within this session and within this conference. Unless there are some additional questions, I would like to thank, first of all the speakers and chairs, all of you in the audience who shared this half day with us, all of you watching the live streaming or the video recordings, which will remain at the YouTube channel of the Serbia National Internet Domain Registry Foundation. Allow me to thank everyone who helped me organize the conference, and in particular my younger colleague, Dr. Novak Vujicic. I hope to see you all back in Serbia, and next year it is time for the 7th conference, Intellectual Property and the Internet. Thank you.